My Lordship, I beg to mention item number 3 on behalf of T. Taba, with the consent of Order 40.
Okay. Mr. Swensel, learned counsel on behalf of Mr. T. Taba, learned counsel for the petitioners, has made a prayer for adjournment, come out with the consent of the learned counsel for the other sides. As sought for how much time?
After 2 weeks.
Okay, list the case after 2 weeks on a date to be fixed by the office.
Lordship, another matter, item number 6 on behalf of T. Tapak,
Apart.
with the consent of Order 40.
Same.
Uh,
2 weeks.
Lordship, this matter may be listed on 28.
28.
Yes, Lordship.
Hmm.
28 April.
Yes. 28.
May it please the Lordships. Lordships, may I please beg to mention an item for listing?
Item for listing?
Yes.
Yes.
The item was supposed to be listed on the 26th of last month, but it has not been listed yet.
When do you want?
Criminal appeal. Anytime in the first week of May, Your Lordship.
Okay. First week of May. 7th of May.
7th of May. Deeply obliged, Lordships.
Give the mention memo.
Your Lordship, I beg to mention item number 2.
Item number 2.
I'm on behalf of petitioner. Your Lordship, kindly may the matter be adjourned for today.
Wait for your turn. Item number 2 only.
Yes.
Wait for your turn.
Pardon, sir?
Wait for your turn. Please wait for your turn.
Sir, my Lordship, the matter may be adjourned for today there. Okay.
Lordship, I beg to mention item number 15.
Yes.
Matter may be taken up after 2 weeks.
You know for the appellant?
For respondent, Lordship.
Respondent.
Yes.
Okay. Yes. Who is for the petition appellant?
Lordship, I'm for appellant, Lordship.
Pray for adjournment.
Yes, no.
Yes. When?
After 2.
After?
2 weeks, Lordship.
Okay. This is you are Mr.
See, Lordship.
Okay. Learned counsel for the respondent has made a prayer for adjournment. Mr. Also learned special public prosecutor for the appellant NI who is present has agreed to the prayer for adjournment as sought for release the appeal after 2 weeks on a date to be fixed by the office.
Okay.
Lordship, item number 4.
4.
Yes. In item number 4, I put a petitioner.
This is PIL. Okay, let us wait. Let us wait.
Item number 1.
Marvelous, my lord. My lord, so far this case is concerned, my lord, since 26/9/2025, government is taking, my lord, time for instruction. And specifically, my lord, on the order dated 18 February 2026, my lord, the order was passed by this honorable court to pass the, my lord, file the written statement affidavit in opposition in detail. And so far, my lord, the notice has not been issued. Therefore, my lord, I have not taken a step to the private respondent. I am praying for, my lord, issue a notice upon the private respondent, my lord.
Private respondent?
My lord.
What kind of
Respondent number 7.
PIL?
This PL is, my lord, basically against the department and a private respondent.
May I, Your Lordships?
This one? No? No. Yes, petition was a tender. Tender for
May I, your lordships? Your
Okay. Huh. Okay. Yes, state respondents
yes,
have
your
been
lordship.
granted opportunity to file a comprehensive affidavit.
Yes, your lordship. On behalf of the PWD
He was a
department.
tender only. He was the contractor only.
No, my
The private respondent is a contractor only
lord. My lord.
for a job. But it is the responsibility of the state.
My-
Yes.
Yes, your lordship. On behalf of PWD, your lordship, we have received the instructions, but the forest instruction is also needed, your lordship. So I may be granted 2 weeks time for that, your lordship.
You filed affidavit in terms of the order.
Yes, your lordship.
Mr. C. Modi,
Right.
learned counsel for the PL petitioners, is present. Heard. And Mr. S. Tapin,
Why Ram, your lordship?
why? So-and-so, learned so-and-so for the state respondents. Mr. So-and-so has submitted that he needs 2 further weeks time to file the detailed affidavit in reference to the order dated 18/2/2026. Post of reply is allowed to raise the case after 2 weeks.
All right.
Obliging.
Item number 2.
Your Lordship, I beg to mention item number 2. Lordship, today we were supposed to file additional affidavit along with certain documents. However, we have filed RTI for those documents, which is still not yet provided by the department.
So
Lord, I'm seeking for an adjournment.
you are putting the cart before the horse. First you file the PIL, then you file the RTI. It should have been other way around. First RTI, then PIL.
Lordship, I have taken consent from the other side, so kindly adjourn for today.
On the prayer of Mr.
Prayer for the matter may be kindly
On the
picks up
prayer,
4 weeks.
your name please.
K per May.
Learned counsel for the PIL petitioners to file
Or else he may withdraw.
Yes, if better get the information, then come. Why you keep the constitutional court waiting?
Yes, Your Lordship.
You file with proper particulars, whether the building is proper or not.
Yes, Your Lordship.
You file the PIL first by having a look from the outer side. While going, you have seen, oh, this building is being constructed. Let us file an PIL, then get the information.
Your Lordship, the
Who is leading you?
K Taris, Your Lordship.
Is he present or not?
No, sir. No, sir.
Next week. Okay. We put it in the next week. Please tell Mr. Tariq to be present. Tell him,
Okay, sir. Yes, Lordship.
cart before the horse.
Yes,
On the, so release the case on Wednesday. Oh, on Tuesday.
Next week.
Item number 4.
Yes,
On behalf,
there was a prayer. Yes,
Your Worship, this order may be listed after 2 weeks.
and for you,
no objection, Your Lordship. No objection.
no instruction, no, but you have to file the affidavit,
We have filed, Your Lordship, on behalf of
file,
respondent number 3, Your Lordship.
that will be sufficient.
For others, yes, we need some more time, Your Lordship.
Uh-huh. Who is she?
3 is, Your Lordship,
State lottery.
yes, Your Lordship,
Ah,
Secretary,
sufficient,
State
don't
Lotteries.
that will be sufficient, I think. Okay. I think that will be sufficient.
Your Lordship,
Affidavit of respondent number 3 is the Secretary, Department of State Lotteries.
yes, Your Lordship.
I think he is the head
Yes, Your Lordship.
who controls lotteries.
Yes, Your Lordship.
Okay.
Yes, Your
What time you need?
After 2 weeks, Lordship.
After 2 weeks. For what purpose? To file any reply or to make submissions?
I don't know.
Huh?
The leading
No idea.
Lordship is out of station.
Okay, on the prayer of Mr. So-and-so, learned counsel for a petitioner is the case after 2 weeks. The affidavit in opposition on behalf of the respondent number 3 has already been filed. First of the petitioner. Shall ensure that its reply to comma, if any, is filed within 2 weeks' time.
Item number 5.
May I please, my Lord?
Yes.
My Lord, this appeal is being prepared, being agreed by non-granting of interim.
Non-granting of interim.
Yes, my Lord. By
What is the matter about?
My Lord, here, with fact of the case that earlier I was transferred,
Appellant is serving as what?
Deputy Registrar of Cooperative Society.
Deputy Registrar of Cooperative Society.
Yes, my Lord.
Okay.
He was serving at 0. Then he was transferred to
Oh, is the impugn order?
impugn order is, my Lord, page 17.
Page 17.
I have impugn 2 order. One is page 17 and another one is, my Lord,
Another one,
page 48. Order passed by the Honorable Single Judge.
25th February. This page 17 order has been challenged in the writ petition.
Yes, my Lord.
Okay, let us see.
Yes, ma'am. My Lord,
Continuation of earlier corrigendum
yes, my Lord.
issued on so-and-so. Gyati Kobing is released from his working station Ahol Lagoon and to join his posting to the concert. Another same fact. What is this corrigendum?
Corrigendum is, my Lord, page 41.
Who is it corrigendum or
Corrigendum means, my Lord,
who is it 13/3/2025? 13/3/2025?
uh,
13/3/2025 order,
page 34, my Lord.
page 34.
Yes, my Lord.
By this order,
By this order, I was transferred to DRC's Tira.
Tira,
Yes, by and showing my
continue to hold the additional charge of so-and-so.
so,
Okay,
and here my present place of posting was shown as head office.
head office. Then what is
And
the
then,
corrigendum?
And then I have submitted representation that
What is a corrigendum?
corrigendum, thereby, my lord, I have been, order has been modified. I have been retained at the headquarters instead of Tirap, DRCS Tirap, my lord. It's page 41, parcel modification, my lord.
Base 34, this is wrongly typed or what? 13th March 2024? Okay, okay.
Yes, my lord. And
Okay,
that,
okay.
that is different.
In parcel modification of transfer order of even number, the working station. Yes, by corrigendum, working station,
Yes, my lord.
working station.
Yes, my lord. And thereafter, my lord, since I was retained at the headquarters, thereafter I was given additional charge of DRCS Tirap by order dated, my lord, 4th July 2025, page 43, my lord.
43.
Serial number 5, my lord.
43.
Yes, my lord. Serial number 5. I was given additional charge of DRCS Tirap, my lord.
Additional charge.
Additional charge.
Yes.
Now, my lord, my thereafter, my lord, impugn release order was issued. Now, my contention is that, my lord, the earlier transfer order is
Released from working station, Naharlagun. Naharlagun means head office.
head office, my lord.
And to join his posting place. Posting place. Posting place, T-Rap. Yes, what is wrong with it?
Here, my lord, things that the transfer order has been modified, my lord.
No, what kind of, original is place 34.
Yes, my lord.
Present posting head office.
Head office, my lord.
There was some inadvertence, wrong,
Yes, my lord.
something wrong.
Yes, my lord.
But your place of posting is DRCS T-Rap,
Yes, my lord.
right?
Hmm.
By the corrigendum, your working station has been made as head office,
Head office, my lord.
right? Instead of T-Rap.
Instead of Tirap.
That is a part-time arrangement.
And no, my lord, actually, this is,
An additional charge is different, but your substantive post
my lord.
is by the release order.
Yes, my lord.
You have been sent to join in the substantive place of posting.
No, my lord, my content is that my initial transfer order has been modified, my lord. And thereafter, I was given additional charge of Tirap.
Transfer and place of working is different.
Yes, my lord.
Place of transfer is different and your working station is different. By corrigendum, your working station has been made head office instead of Tirap. But your place of transfer remains Tirap. Is it not?
But, my lord,
Then this is only release order.
my lord, after the corrigendum, my lord, I was given additional charge of Tirap. If I only my place of working
Additional charge will not change the nature and character of the transfer.
my lord, what I'm trying to point out is that if my this corrigendum is only for my place of my place of working, then this additional
You
charge
have
order would not
basically-
have been issued.
It
My
has
lord.
been, you have been attached at head office
Head office.
instead
If,
of Tirap.
Yes, my lord. If that had been so, my lord, this July order would not have been issued, thereby giving me the additional charge of Tirap, my lord. If I were already holding that charge, then I cannot be assigned additional charge of that post, my lord.
Now you have been given full charge.
No difficulty is that, my lord. Now my submission is that, my lord, if this modification is only for the change of, my lord, working place, then I would not have been given additional charge subsequently.
That
But I'm
was,
saying
see in between 13th March 2025
25, my lord.
and 25th February 2026,
Yes, my lord.
right?
Yes, my lord.
Those were working arrangement. This was not changed. It was by issuance of a corrigendum, it has been changed.
Changed, my
That,
lord. Yes.
transfer order,
Yes, my lord.
right?
Yes, my lord.
But it was not withdrawn.
Not withdrawn, but
Not withdrawn.
but
It was,
my
it
lord,
was, it
modified,
was
my lord.
kept in basically suspension.
Yes, ma'am.
But by this release order, you have been allowed to go.
But my lord, since corrigendum was issued and I have been given additional charge of the post where they are sending me now. What I'm saying is the transfer posting order has been already complied, my lord. On the basis of that order, I cannot be, my lord, released. If authority want me to send there, they can issue fresh transfer order, my lord. Instead of referring the old transfer order, which I have already
Let us
complied.
see the impugned order.
Impugned order, my lord, is 11% page 49, my lord. 48, starting from 48. May I read, my lord?
Yes, corrigendum is what? Corrigendum, your working station has been made head of Naharlagun.
Yes, my lord.
Or the temporary thing. But place of transfer remained as Tirap.
No.
And while working in the additional at headquarters, you have been given additional charge of Tirap, DRCS.
Yes, my lord.
Now you have been allowed to go there
Yes.
to take full charge.
No.
That is all.
My lord,
Corrigendum is not, corrigendum is for some clarification.
yes, my lord.
Earlier you were at 0.
Yes, my lord.
Instead of 0, it was mentioned as headquarters.
Yes.
So they, by way of corrigendum, they have corrected it. And
No, my lord,
say that you, for a time being, you be placed in the head office. Working.
Yes.
That is an,
My lord, my humble submission
No
is that my, once corrigendum is issued,
no
it will
point.
go to the order.
Where is the infraction of any say, rules?
My lord,
No, no rules.
but
Statutory rules are violated.
my humble submission that my lord,
You
there
pass
should
to
be,
the repetition.
my lord, there should be, my lord, subsisting present transfer order in order
That
to
all
be
remains.
released. And my submission that my
That
once,
your contention is not acceptable. That you already have advanced before the learned single judge that ceased to exist. That is not acceptable.
my lord, may I submit to me? For example, my lord, board of your lordship is here because of the roster, my lord, issued by the our honorable High Court. Suppose if weekly roster is changed by the our High Court, instead of Itanagar bench, lordship would be sitting at the Guwahati. Then that will, my lord, the corrigendum will take effect and
No, our roster
Directly-
is not comparable to transfer and posting.
my lord, no, my
Right. Don't compare.
my lord,
Analogy cannot be brought in that manner.
my lord, once what I'm submitting is, my lord, once transfer order is
If you
issued-
take the analogy,
Yes,
we
my lord.
travel across the 4 states
Yes, my lord.
after every 2 weeks.
Ah.
My lord.
You are within the state.
Yes,
So
but my lord,
in that
all of-
case,
What I'm trying to point out that
Petitioner-
every movement from one court to another.
Okay,
Court issues
appellant wants to be,
separate issue, my lord.
wants to have a service as like us, then you have to move around for every 2 weeks.
What I'm trying to point out is, my lord, for every movement, there has to be separate order.
You are
Not
quite settled.
referring the all the, this the
No,
roster, my lord.
Mr. Laji, we don't find anything. Two options, we dismiss or you pursue before the,
My lord, since, my lord, there is,
no point.
once, my lord, the corrigendum is issued, my lord,
Post is vacant, you go and fill the post.
Sorry, didn't think this. Sorry, I was asking him.
Yes, Mr.
My lord. My lord, in corrigendum, it was clearly mentioned, my lord. Number one, my lord, his place of working was changed, my lord. It was especially mentioned on headquarters. Then, my lord, corrigendum also says, my lord, in continuation, my lord. Now, my lord,
Basically, the wrong was
only, my
present
lord,
posting in page 34, present posting, instead of head office, it should have been
my lord, 0.
0,
Correct, my lord.
right?
Right, my lord.
Then we have no option. Heard
My-
Mr. D. Laji.
my lord, my only issue is if it was that the corrigendum was only temporary arrangement, then my lord, why I would be given the additional charge of the TIRAP where there, my lord.
Because
pending
you were
now, my lord.
working at headquarters
Headquarters, my
and
lord.
that post is vacant,
Correct.
right? So you were given the additional charge. Now by releasing you, you have been allowed to take full charge.
No, my lord, for that, my submission, there should be, my lord, press transfer order. They were transferring me from headquarters to the TIRAP, my lord.
So we are on the interim prayer. We don't
Yeah,
find
my lord,
anything.
what I'm submitting is, my lord, there is no valid relevant transfer order on the basis of which I can be sent to the TIRAP. If they want me to.
No, by way of corrigendum, whether the transfer order, substantive transfer order has been superseded. No.
My
But
lord,
corrigendum, the original order is not superseded.
so far as my lord, my understanding.
Fact of the matter is that you have been transferred to.
My lord, so far as my understanding, corrigendum relate back and substitute the original order, my lord, to the extent it corrected in the corrigendum.
Substitution is different, sir.
My lord, corrigendum is basically if modified.
Let us
that
see the understand the meaning of corrigendum.
substitute- My lord, corrigendum
See at the
basically.
Google University.
My lord.
Google Baba.
So far as my understanding, the corrigendum is normally issued for the correction of the original order, and that will once corrigendum.
Whether
issued-
DRCS TIRAF has been corrected.
But corrigendum it, doesn't say, my lord.
Corrigendum is silent, so that remains.
So it means, my lord, I will be written at the headquarters, my lord. This silence means I will be
It is
written at the
see
headquarters.
the wording, working station. Because you pointed out Tura or what, 0.
0.
You pointed out in your representation that this should have been 0.
Partial modification, may I read the, my lord, the corrigendum, my lord. Partial modification of the transfer and order of the event number dated 13 March 2025. The working statement getting in DRCS appearing in serial number 3 of the said order shall be in the head office instead of TIRAP district, my lord. Hereby it modifies, my lord, and substitute the original order date. My
Organization,
place of the posting will be the headquarter, my lord, not the TIRAP. And accordingly, my lord, subsequently I was allowed the TIRAP district, my lord, additional charge. If I was to work as a DRCS TIRAP at the headquarters, then why I would have been given, my lord, additional charge of the DRCS TIRAP.
heard Mr. D. Lijo, Learned Counsel for the Read Appellant, and Mr. Nabam, Learned Additional General or Natural Police. For all the respondents. Full stop. Para this intercourt appeal is preferred against an order dated 19/3/2026 passed by a single judge in a writ petition WBC number 110/2026 preferred by the appellant as a writ petitioner. Post of the petitioner, the appellant, as writ petitioner is a government employee and he is presently in the rank of Deputy Registrar of Cooperative Societies within bracket DRCS. Full stop. In the writ petition, comma, the petitioner, sorry, appellant writ petitioner has assailed an order dated 25
Yes, to debate.
2026. A release order by an order dated 25/2026, comma, which is a release order, comma, whereby the appellant writ petitioner has been released from his working station, that is Naharlagun, on 27/2026 within bracket AN, enabling him to join his place of posting at Khonsa as DRCS Tirap in pursuance to an order, previous order dated 13/3/2025. Full stop. Para. By an order dated 13/3/2025, comma, 3 number of DRCS and 1 ARCS, Assistant Registrar of Cooperative Societies, were transferred from one place to another. Post of the appellant petitioner at that time was serving as DRCS 0. Post of. By the order dated 13/3/2025, comma, the appellant petitioner was transferred to transferred as to what is the district? Tirap. Okay. Transferred as DRCS Tirap, while allowing him to continue hold the additional charge of AW. What is this? Fed Limited. Federation or what? Federation. What is the full name? Federation. This is AWFED Limited. Full stop. In the order 13/3/2024, comma, the present place of posting of the appellant, the petitioner, was mentioned as quote unquote head office. Full stop. The petitioner, appellant petitioner, alleging untimely transfer and posting and raise a grievance as regards his untimely transfer and posting in a representation dated 13/3/2025, wherein he pointed out that he had been transferred from 0, but in the order of transfer, it was incorrectly mentioned as quote unquote head office, post office. The order dated 13/3/2025 was followed by a corrigendum dated 25/3/2025. It is signed, na? Sign will be, it will be that day.
It should be there, but issued on this.
By corrigendum dated 25/3/2025. Post of. The corrigendum was issued in partial modification of the order of transfer dated 13/3/2025. And it was clarified that the working station of the appellant petitioner in the order of transfer should be read as should be head office instead of Tirap district. Full stop. Pursuant to the corrigendum, the appellant petitioner was serving in the head office at Naharlagun.
Yes, my lord.
Full stop. Subsequently on 4/7/2025. Which page?
Page 43, my lord.
The appellant petitioner was given additional charge of DRCS Tirap. Full stop. By the impugn order, but it is the case of the petitioner that he started discharging the additional charge of, while working at the head office at Naharlagun, started discharging the additional charge as given by the order dated 4/7/2025. So by the impugned order, which was issued in continuation of the corrigendum dated 25/3/2025. The petitioner has been, appellant petitioner has been released from his working station, i.e. Naharlagun, on and from 27/2/2026 to enable him to join his place of posting at Khonsa as DRCS Tirap in terms of the order of transfer, original order of transfer dated 13/3/2025. First of, aggrieved thereby, the petitioner, appellant petitioner has preferred the writ petition. First of the line single just. By the order dated 19/3/2026, while issuing notice returnable in 4 weeks, has declined to grant any interim relief. Full stop. Mr. Raji, learned counsel for the appellant petitioner, has reiterated his submission that with the issuance of the corrigendum dated 25/3/2025, the earlier order of transfer dated 13/3/2025 stood superseded and thus cease to exist. Full stop. With there being no new transfer order. The impugn order dated 25 to 2026 is to be termed as illegal and arbitrary. Full stop. Para. By the order of transfer dated 13/3/2025, the petitioner, appellant petitioner, who was then serving as DRCS 0, has been transferred as in the same post and rank of DRCS, and he has been posted at TIRAP. Full stop. Though in the order dated 13/3/2025, it was mentioned his present place of posting was mentioned as quote-unquote head office. But that did not have any impact as regards the order of transfer made. Order of transfer made to that did not impact as regards the place of transfer of the appellant petitioner to TIRAP. First off, by the corrigendum it was by the corrigendum. Page. The corrigendum dated 25/3/2025 was issued in partial modification of the order of transfer dated 13/3/2025. And in the corrigendum, it was mentioned that the appellant petitioner's working station would be in head office in state of TIRAP district. First of thus, by the corrigendum, the petitioner was allowed to work in the head office and was not required to join immediately as DRCS TIRAP. First off, while working as in the same rank and post of DRCS at the head office, the petitioner was allowed to hold additional charge of DRCS TIRAP by the order dated 4/7/2025. So the order dated 4/7/2025 is stated to be an order of work allocation for senior officers in the office of the Registrar of Cooperative Society, so that none of the scheme implemented by the Department of Cooperation, Government of Arunachal Pradesh, is neglected. Full stop. Thus, but neither by the corrigendum nor dated 25/3/2025 nor by the order dated 4/7/2025, the original order of transfer dated 13/3/2025 has been superseded. First off, by the release order, by the order dated, impugn order dated 25/2/2026, the appellant petitioner has only been released from his working station. That is the head office at Naharlagun, with effect from 27 to 2026. In order to enable the appellant petitioner to join his place of posting as at Khonsa as DRCS Tirap in compliance of the original order of transfer dated 13/3/2025. Closed up. An order of transfer and a transfer order and a release order are of different nature. Closed up. Para. Therefore, in view of the above fact situation, Commander's Court does not find any reason, not to speak of good and sufficient reason to interfere with the order dated 19/3/2026, passed by the learned single judge. Full stop. The petition, appellant petitioner, in the impugn release order. Order? The learned single judge has observed that the impugned release order would be subject to the outcome of the repetition. And we reiterate the same purpose. Reiterating the same observation, the appeal stands dismissed. Anything to do with it?
No.
Item number 7.
GIL. Many cases, huh?
Mm.
Basically forest.
This is very one of the.
Yes.
My lord, this PIL pertains to, my lord, the construction of the package B of the national highway. Construction or lack of construction actually, my lord.
Lack of construction.
Yes, absolutely. This road was supposed to be completed on 7th of February 2024. Package B, my lord, Naharlagun section. The road which passes through the township area. 7th of February 2020 was supposed to be completed. There's supposed to be a flyover containing that 149 pillars, and everybody has seen what is the stage of this road. On the last occasion, your lordship will see.
My brother is in better position
Yes,
to.
your lordship will recall on the last occasion.
Huh.
My learned friend was supposed to, my lord, get back with instructions.
6-4.
6/4.
Well, I will see the last order, not in 6.
Contract. Mr. Dubey, you present which?
Respondent number
Contract.
7, Lord, the
Respond
contract.
number 7,
Yeah.
contractor.
Well.
You were awarded the work.
Yes.
This court has been informed that do a notice of termination of the contract along with the individual with just removes put to challenge the Indian application and that's when before the district judge EPR, which an interim order was passed 5/3/2026. The pertains to aspect restraining the termination of contract and encasing the bank guarantee. If it is, Mr. Dubey, it is your admission that it is not possible for you to continue the work.
Let me indicate not. In fact, in terms of last order, not what has happened, my lord.
Lord, as my learned friend says, he's right, Lord, that the last date for finishing of the work was in December 2024. Lord, we also had our issues regarding Lord handing over Lord site and Lord non-payment of bills. That irrespective of that,
Let us
Lord,
not go back to that.
no, Lord, just I'm indicating to Lordships. What I have come before your Lordship is this. Lord, we could not seek any remedy in this case because we are respondent, Lord. We decided to seek our remedy before arbitration. Now, Lord, a situation arose, Lord. There was an interim order in my favor, Lord. There is a termination notice. And then your Lordship says, Lord, that it can't happen that way, Lord. On one hand, Lord, there is no work going on and there is a stay. And Lord, that's why I indicated if your Lordship see the last order that we will come
Not
with.
that. You cannot walk and you obtain this. It's not that. It's not the walking.
No, Lord.
not
May I
walking
clarify,
going.
Lord? Your Lordship
You
definitely.
have said it's not
No,
possible
Lord.
to complete.
Lord, let me clarify what I said.
No, what we have understood.
Lord,
Sir, you just cannot
no.
take this.
My Lord will definitely. Lord, what we have stated was, Lord, till 31st July, we had got Lord extension. And by that time, we would not be able to complete. But this was the position. I'm not saying that, Lord, that's in Lord, wrong statement. Your Lordship had queried and Lord, we
Did we
responded.
say that you have made a wrong statement?
No,
But
no,
we
no.
said you don't submit unnecessary things now.
No, with due respect, Lord, what we said and we stand by that, Lord, that by 31st July we could not. And therefore, Lord, we had represented to the authority that we are entitled for extension, Lord, intercontractual terms. They decide or not decide, it's their call.
Already recorded,
Now, Lord,
sir.
now,
Para 3.
yes, Lord.
So, I mean, under the president, it was not possible them to continue
To
work
complete-
and therefore
complete.
approaching the court.
Yes, Lord.
Already expressed.
Lord, what we had stated was that we are entitled to extension. If that authority extend that, then we can complete. But 31st July, Lord, we cannot complete. I still say that. But then we went for Section 9. Now, on last occasion, what has happened? Your Lordship has asked me, Lord, what is the situation? Lord, I had taken instructions in detailed discussions, Lord. Now, Lord, the ball is in the court of the authority. Lord, I have taken specific instructions, Lord.
What is the position now in the arbitration case?
Lord, I have taken instructions, Lord. We are going to withdraw the arbitration, Lord. Because if at all, Lord, what has transpired from your Lordship also, Lord, if it is a case for compensation or damages, we can go ahead with that. And the work should not be stuck up, Lord. That's why, Lord, on last occasion, I had made a submission that I'll take instruction from my client. And it is very clear, Lord, that since though we had an interim order, Lord, we could not proceed with the work. That's Lord, the correct situation. So it can't remain like that, Lord, because the public is also suffering. This is also a factual position.
Because suppose
My lord.
employer did not or do not accede to your
My Lord,
prayer for extension,
my Lord.
then the only option for the employer is to go for
my lord.
termination.
Yes, and whatever the
So
other
if the
remedy I would have,
termination is in terms of the contract agreement,
My lord.
well and good. If it is in breach of the contract agreement, you have the remedy for
yes. So, Lord, if at
damage,
all that be, we can only
compensation.
go for remedy as regard damages and all, Lord. The work should not be stalled, Lord.
Yes.
That is my instructions. And my instruction is very clear that we are going to withdraw that arbitration petition, Lord. Your Lordship may also record it. But I have one aspect for your Lordship's considerations, Lord. Now, once the stay order goes, Lord, it's the department who has to decide on termination. They have already issued a notice. Lord, there has been meeting with the Director General Morth in Delhi, Lord. And where, Lord, there was discussions, Lord, because of the financial constraints, the work could not go ahead also. This was also an issue. And Lord, we have been asked that if at all you can work, Lord, you have
That
to
will be
infuse.
taken care of in the PIL regarding fund issue
Yes, yes.
of the state.
Lord, my submission for your Lordship's consideration is, Lord, your Lordship may record that we are going to withdraw this arbitration. Second, Lord, they have issued a termination notice on 13/2. Lord, your Lordship may just give us liberty. We'll submit a response to that and authority can decide. Lord, we will also come with a proposal. If they agree, agree. If they don't, they don't.
That liberty you
within
can
the-
seek from the court where you have filed a petition under 9, right?
Well, that perhaps-
the region could very well be
Now,
explained there.
we want to put the entire.
Why in a PIL we will
No. I'm
that
just
contract agreement is not the
Subject matter,
of the
yes,
PIL. We cannot simply say that we will only observe that you have the instruction that the respondent number 8 or 7 is
Seven.
going to
Withdraw the arbitration.
withdraw the arbitration case
My lord.
and to place instruction, up-to-date instruction on the next date, because there is
My
an interim order operating.
Yes, my lord. Well, that we'll do today. My lord, it's been fixed. In fact, it was fixed
We
yesterday.
cannot, we
I could
cannot ignore that interim order also.
That I have.
As a result, everything stalls.
Yes, that's true, my lord.
This overbridge is for last decade, no?
It started in 21. Your lordship, my lord, just wanted to point out, they are saying that they are going to withdraw the.
Almost a decade.
Ultimately, this contractor might not know what their end game is. In September, your lordship, my lord, Justice Ette will recall, on 26/9/2025, they gave an undertaking before this court that earlier the work was not being done, but now we have arranged
Okay,
the
let us
finances.
let us, if they are going to withdraw this arbitration case, then thereafter things should be
Yes.
open.
My concern is the construction of the whole
Right.
working season has been wasted.
So what is the next date, Mr. Dubey?
Today.
Can it be? Today, my lord.
Today, arbitration
It's been
case.
fixed today.
Okay.
I am going there, my lord.
Okay, you'll do it.
I'll have instruction.
Okay, we can put it in the next
Next
week
week.
so that you can obtain
Yeah.
the instruction.
Yes.
Thereafter, you can proceed
Yes.
against the state respondents.
Today, it may be recorded that.
Yes,
Yes,
I'm
yes.
saying.
I heard Mr. D. Panging, learned counsel for the petitioners. Mr. N. Rotron, learned additional advocate general, Arunachal Pradesh, for the state respondents, and Mr. R. Dubey, learned counsel for the respondent number 7. Full stop. On the learned counsel for the parties have advanced their submission in continuation of the previous order dated 6/4/2026. Full stop. Mr. Dubey, learned counsel for the respondent number 7, has submitted that arbitration case number 01/2026 is posted before the court, which is pending before the court of learned district judge UPA, is to be taken up for consideration today. First of Mr. Dubey has submitted that he has instruction to apprise the learned court that the respondent number 7 would not be pursuing the case further in order to avail appropriate remedy under the contract agreement it had executed with the employer. First off, Mr. Dubey has submitted that he would be in a position to apprise the outcome of the proceedings in arbitration case number 01/2026 in the next week. First off, in view of such submission, let the case be posted
Can it be on 28th, my lord?
on 28th. 28.
The word withdraw and has agreed to withdraw. That withdrawal word.
He'll be here on Tuesday. Will not say.
My friend will get the result today itself, my lord.
He's coming back again on Tuesday.
What you have done? What have you done?
No,
Well, they have filed an objection on last date, my lord.
the whole working season is lost, but that is my concern.
Today is Thursday, let us wait till Tuesday.
Deeply applied.
Item number 8.
My lord, this is contempt, my lord, for violation of the judgment and order dated 9/4/2025,
9/4/2025.
page 36 onwards, operative part.
Yes, 36.
My lord, this was kept pending, my lord, because that filed an SLP before the Honorable Supreme Court. That has now been dismissed, my lord. Listed of certified copies, but I have obtained from the They were in fact represented by current senior counsel Naresh Kaushik, but today nobody appears to be here.
Hmm.
Nine 4/2025.
3001. In this case, notice has been issued.
Yes, but they were represented by learned senior counsel Naresh Kaushik on the last occasion. And they made the prayer that they filed the SLP before the Honorable Supreme Court, so it should be kept.
Okay, heard Mr. D. Panking.
They are not
What a
here
petition.
today again.
Post of this contempt petition is filed alleging non-compliance of the direction given in a judgment and order dated 9/4/2026. 5 passed in a writ petition. WA number 25/2024. Post of. Pass in a writ appeal, huh? Writ appeal number so and so. Post of. Notice the respondents were put to notice by an order dated 3/7/2025. And upon service of notice, all the respondent or single
sir.
respondent?
All the rest.
Both the respondents or all the respondents had entered appearance through their learned engaged counsel. Post of. Para. During the pendency of the proceeding before this court, it was apprised that against the judgment and order dated 9/4/2025, Supra, a special petition, SLP C, diary number 59361/2025, was preferred before the Honorable Supreme Court of India. Post of. In view of, it was apprised on 19/12/2025. In view of the SLP, the case stood adjourned. Post of. Today, Mr. Panging, learned counsel appearing for the petitioners, has submitted that by an order dated 30/1/2026, the Honorable Supreme Court has dismissed the SLP preferred by the Northeastern Regional Institution of Science and Technology, NERIST, and others against the judgment and order dated 9/4/2025. Post of. In view of such development, the learned counsel for the respondents is found absent today on call. Post of. In order to proceed further, this court deems it fit and proper to provide another such opportunity to the respondents for their appearance. List the case on first time they are absent. Some date
30, 34, 30 April.
34. Okay. Have they no, I think no affidavit, right?
My lord.
No affidavit is in file.
No.
30.
All right.
Item number 9.
May it please your lordship. This is
Yes.
jail appeal, my lord. TCR has been called for, my lord, and it has been filed to
Also,
legal aid council, my lord.
also. Notice return. Shall we dismiss or what? No steps, no appearance. Okay, this man has been appointed as public prosecutor. Now we have a cadre, no? But what to do? What is pursuing? Shall we dismiss? Huh? Let us see what is this. Excise appeal, 35Z, final order. Let us see. What is the final order? (35Z). We can put it in the next week. Then what time will, there is no appearance on behalf of the appellant, applicant. Appellant or applicant? IA is for what? Oh, delay. Applicant, appellant. Post of. Though on 2/12/2025, comma, the applicant appellant was directed to take steps for service of notice upon the respondent. The applicant appellant has not taken any steps for service of notice, comma, as reflected in the office note dated 22/04/2026, post of. On the previous date of listing, comma, 19/3/2026 also, there was non-appearance on behalf of the applicant. There was non-appearance on behalf of the applicant appellant, post of. As the accompanying appeal is a statutory appeal, comma, we deem it proper, comma, for range of justice to grant another opportunity to the applicant appellant for appearance. Accordingly is the case on next Thursday. It is observed that in the event of non-appearance, comma, this court will be constrained to observe that the applicant appellant is not interested to pursue the appeal. Application and the appeal.
Item number 11.
Same.
Item number 12.
I.
May I please, my lord? My lord, this is an IA file for condoning delay of 89 days.
Yes, heard, Mr.
Titakap.
Learned Legal Counsel.
No.
Learned Counsel for the applicant. And Mr. Learned additional public prosecutor.
Yes, my lord.
For the opposite party number 1, comma, State of Arunachal Pradesh. Of this application under Section 5 of the Limitation Act 1963 is preferred
on limitation of 1963 is preferred seeking condonation of delay of 89.
My lord, actually, it should be my lord 54 approximately. It's wrongly computed, my lord.
Anyway, we are condoning.
Yes, my lord, but the date is, my lord, actually 54. It should be from the date of sentence, not from the conviction date.
A period of delay. Seeking condonation of the period of delay which is stated to have occurred in preferring the accompanying writ petition, accompanying criminal appeal. Full stop. In the application, it is averred that the period of delay is 89 days, whereas the learned additional public prosecutor has submitted that the period of delay which has occurred is in fact 54 days.
Yes, my lord.
Full stop. Be that as it may. Full stop. The applicant as the appellant has preferred the accompanying criminal appeal. Under section 415B and SS against a judgment and order dated 13/11/2025 passed in sessions case passed by the learned Sessions Judge UPA in Sessions case number 64/2018 stop by the judgment and order dated so and so, the trial court has convicted the applicant appellant for the offences under section 302 IPC and 201 IPC. Full stop. For the offence of murder under section 302 IPC, the applicant appellant has been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000, with a default stipulation. First of considering the fact that as the applicant has been convicted for the offense of murder and has been sentenced to undergo imprisonment for life, and the period of delay is not substantial, this court, after going through the grounds, find that the appellant has been able to explain the delay, showing sufficient ground. First up, in view of the same, the period of delay is condoned. Full stop. Considering the fact that the period delay, for expeditious disposal of the accompanying appeal, the period of delay is required to be condoned, and therefore, the notice to the informant is dispensed with at this stage, as the informant will have the opportunity for appearance at the time of hearing of the accompanying appeal.
Yes.
The registry to register the accompanying criminal appeal and to list the same for admission expeditiously.
Much obliged.
Obliged, my lord.
Item number 13.
Yes, sir.
Basically, challenging the general service rules.
Service rules.
Yes, Group C, multitasking,
Virus. Then affidavit.
Your Lordship, we need some more time to file our affidavit.
Okay, heard Mr. T.T. Tara, learned counsel for the petitioners, as Mr. Sorenso, learned additional advocate general on a protest. Full stop. Mr. Sorenso, learned additional advocate general has sought for brought on.
Your
Has sought
Lordship,
for how much time?
3 weeks, Your Lordship.
And is
Your Lordship,
okay.
junior government.
Okay,
Your
junior
Lordship.
has preferred and is granted.
4 weeks time to file the counter affidavit. Release the case after 4 weeks.
Item number 14.
Kilo Roy Bhumi.
May it please your lordship. Your lordship, here in this appeal, my lord, this court has exercised the power under section 391 of the CRPC for fair and just decision, my lord, the additional evidence.
Okay.
My lord, now we are not aware of the status because, my lord, on last occasion we were directed, my lord, but it is supposed to be directed through the registry, my lord, to status of the evidence, how many evidence has been
What is
recorded.
the previous order?
My lord,
411. Okay. Heard, Mr.
My lord, actually, instruction was given by my leading counsel that 2 witnesses has not been examined in the trial. 2 witnesses.
Are yet to be examined.
Yes, yes. And someone has been served to witness.
Someone has been served.
Yes,
Served.
yes, yes.
Okay. Heard, Mr.
Elroy.
L. Rui, learned counsel for the appellant. And Mr. Swenson, learned additional public prosecutor for the respondent state. Mr. Suri, learned counsel for the appellant, has submitted that he has received information to the effect that 2 of the witnesses are yet to be examined. 2 of the witnesses who have already been served with the summons are yet to be examined by the learned trial court.
Yes.
And the case is posted? You don't know?
Yes.
You should have got the information also.
Just instructed by my leading counsels.
Poster. By which order? 391?
my lord, it's
Okay. 7/4/2020. By order dated 7/4/2022. This court had directed for recording of additional evidence. Poster. A period of more than 4 years have elapsed in the meantime. Poster. Registry to call for a report from the learned trial court. Release the case on after 6 weeks. Date.
9 June.
9 June, right? Report.
yes, the status report, yes.
Obliged.
Yes, ma'am. Obliged, ma'am.
Report. Status report. That means
Yes, yes, my lord, yes.
Item number 16 and 17.
Islamuddin Abdul Ghafoor.
May it please your lordships, I am for appellant in item number 16, lordship. So lordship, otherwise I am ready. I can.
Who is the appellant in 17?
17.
Ready?
Your Lord,
Not ready.
no, all the parties are ready, Your Lordship. I have been informed that the counsel for the informant, Mr. M. Nivo, Your Lordship, is out of station, Your Lordship.
What is the offense?
Lordship, kidnapping, the alleged offense is kidnapping and murder. And the punishment is given only for kidnapping, lordship. 364A,
Not for murder.
not for murder.
But 364A is kidnapping for murder.
Kidnapping for ransom, lordship.
Ransom. Oh, sorry. 364A.
Lordship.
I think life.
Life imprisonment,
Life.
lordship.
Yes, half ready.
Actually, altogether, there is.
And who is for the victim or informant?
Your Lordship, counsel M. Nivo, Your Lordship, he is not present today.
M. Ribo. Yes. He may have some say. He is near or dear ones might have been
Lordship.
Okay, then we defer. So you are ready?
Yes.
Madam is ready. You are not ready. Okay.
Yes. To be honest.
And Nibo is absent.
Yes, sir.
And sought accommodation.
Yes.
Okay. Mr. Medhi,
Lordship.
DJ Medhi,
No, Lordship, PP Medhi.
PP Medhi, learned counsel for the appellant in which one?
16, Lordship. Item number
16.
16.
And Miss So-and-so, learned additional public prosecutor for the respondent state are present. First up. Mr. H. Lampu, learned legal aid counsel, has sought for an accommodation. First up. Ms. So-and-so, learned additional public prosecutor, has submitted that Mr. M. Nibo, the learned counsel, who represents the informant,
Yes.
has made a request to her to apprise the court for an accommodation also on his behalf. First up, in view of the above, the list the appeals on so and so. Give the
Lordship, may date may be fixed, Lordship.
after
I'm obliged, Lordship.
5th May,
5th May.
soon. Many cases are fixed already.
then 7th,
End of
7th.
May. End of May.
Huh?
End of May.
29
End of May.
End of
No, not me.
not May.
April.
Okay, then
If it is
30,
possible, if not, then as part of convenience of
30.
this honorable court.
30 April,
When do you want?
Lordship, either 29 or 30
30,
Of May.
April, Lordship.
No, not possible.
5th of May. को ले लो।
May.
5th of May.
29, 29 May.
29 May.
May.
29 May is Friday.
5th May बोला था।
Mera-
Okay.
28 May.
28 May.
आपको okay with it? I'm obliged, Lordship.
Yes, you be ready.
Item number 18,
May I please?
Yes.
This is a appeal, my lord. Against the, my lord, impugned judgment dated 26/3/2025, my lord,
Mhm.
and the consequent impugned order on sentence, my lord. Passed
You
by
are
the-
ready?
My lord.
Okay.
My-
Can we come back after 5 minutes?
May I please? My lord, this,
Where is the judgment otherwise? Page?
my lord will find. Impugned judgment, my lord will find.
Okay,
Page
page
number,
60.
starts from page number 62, my lord.
Okay. And conviction is under?
Under section, my lord, 6, my lord.
POCSO.
Yes, my lord.
Okay.
Penetrate,
Yes.
May I please, my lord. My lord, I beg to mention item number 9, my lord.
9.
My lord, I may be allowed some time to file my reply, my lord.
Okay. Mr. So-and-so, learned counsel for the
I-
petition,
Taking the consent of the other party, my lord.
has sought for how much time?
3 weeks time, my lord.
3 weeks. The sought for and is granted 3 weeks time to file a reply affidavit. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer.
My lord,
Is
there is
the
an,
case accordingly after 3 weeks,
my lord, there is an
needed to
interim,
be fixed by the office. Interim order.
yeah, my lord.
The interim order passed earlier shall continue till the next.
Obliged.
My lord, I'm mentioning item number 2.
Item number 2.
The council is not keeping well today, your lordship.
Okay.
m-
On the prayer of Mr.
Piron, Your Lordship.
P. So-and-so, learned counsel on behalf of Mr. Z. Mann.
No, Mr. Firoz Khan, Your Lordship. Firoz Khan, he's an outstation counsel, Your Lordship.
Okay, on behalf of the petitioner. When do you want?
After 2 weeks,
This is the case after 2 weeks.
my lord, one more matter. Item number 13, Your Lordship. Yes, service report is still awaited, Your Lordship.
Let us see 13. Mr. So-and-so, learned counsel for the petitioner is present. In view of office note dated 22/04/2026, await further service reports in respect of the respondent. Release the case after 2 weeks on a date to fixed by the office.
Bless you.
My Lordship.
Yes.
Lordship, I beg to my item number 5, Lordship. Lordship, item number 5.
Yes.
Lordship, I need some time to file our affidavit. I'm from for the department, Lordship.
Department, which
Yes.
department?
Horticulture department, respondent 2 to 5.
Okay, you have informed the
Yes,
petitioner.
yes, Lordship.
Okay, Mr. So-and-so, and standing counsel horticulture department has submitted that he is yet to receive the necessary instructions to file the counter affidavit and has thus sought for how much time?
3 weeks, Lordship.
3 weeks time to obtain necessary instruction and to file the counter affidavit on behalf of the respondent authorities in the horticulture department. It is submitted that consent has been taken from the learned counsel for the petition to make the prayer. The prayer is allowed. Release the case after 3 weeks on a date to be fixed by the office.
Deeply obliged.
My Lordship. Lordship, I beg to mention item number 10, Lordship.
10, yes.
Yes, Lordship. I am for respondent number 7, Lordship, private respondent, Lordship. I have informed the petitioner, Lordship. Yes.
My lord, I have objection, my lord, here in item number 10, my lord. Can it be fixed on, my lord? Yes, on 29, my lord.
Lordship, the conducting council is our station council, Lordship, and next week, Lordship, he will not be able to come, Lordship.
What is his name?
R. Bishwas, Lordship. Rituraj Bishwas.
What is the matter about?
My lord, compensation matter, my lord, this private respondent.
Compensation.
Yes, my private respondent has obtained the award, my lord, by committing fraud, my lord. The compensation.
When he will be available? Next week?
Lordship, first week of May, Lordship.
Okay, then.
Then, my lord, after 3 weeks, my lord.
After 3 weeks?
Yes, ma'am.
Then agree to a date. If he is outstation council again,
Yes, ma'am.
otherwise say that.
So I am accommodating for today.
So, after 3 weeks. Suggest a date after 3 weeks. We'll post it accordingly.
My lord, let it be after 3 weeks, my lord.
18/5?
18/5.
Mr. B. Pichal and counsel for the petitioner is present. Mr.
K. Meena, Lordship.
K. Meena, learned counsel on behalf of Mr. R. Bishwas, learned counsel for respondent number 7, comma, with the consent of the other counsel for the respondents, comma, has made a prayer for adjournment. To stop the sought for and agreed to by the learned counsel for the parties, leaves the case on 18/5.
Obliged, Lordship.
May I, Your Lordship? Your Lordship, with consent of the other parties, I beg to mention item number 11.
11?
Yes, Your Lordship. I'm appearing on behalf of CGC, Mr. K. Loya. Your Lordship, due to certain health issues, he is unable to appear to. Therefore, Your Lordship, this.
Why it has come 11?
My lord, this is regarding compensation. My lord, this may be taken up on Wednesday, my lord.
No, why it has come for orders? Okay. You are for the petitioner. Okay. Mr. T. Patil, learned counsel for the petitioner, is present. Miss So-and-so.
Ojarang, Your Lordship.
On behalf of Mr. K. Loya, learned Deputy Solicitor General,
Yes, Your Lordship.
has made a prayer for adjournment with the consent of the learned counsel for the other sides. Full stop. When do you want?
Wednesday, Your Lordship, 29th of this month.
Release the case on so.
My lord, this item number 3 also may be taken up on the same day, my lord.
My lord, I'm sorry, my lord, they have not taken consent, but 29, my lord, I'll be not here. I'm handling this case.
Okay.
They have not taken.
Item 11. Item
Yes,
11.
28.
Then May, first week, 4, 5.
4, 5, any date, 4, 5.
4, 4?
4 or 5. Monday or Tuesday.
Not on 4, on 6, my lord.
6.
Much obliged.
Lordship, I like to mention item number 15.
15.
I'm for the petitioner. I informed the, yes, 15.
Petitioner.
Yes. I informed the other side, Lordship.
Okay.
Maybe taken up after
Mr.
3 weeks. Yes, Your Lordship.
Learned counsel for the petitioner has made a prayer for adjournment of the case for 3 weeks. It is submitted that consent has been taken from the learned state counsel to make the prayer. First of list the case, the prayer is allowed, list the case after 3 weeks as sought for on a day 2 weeks by the office.
My lord, item number 3,
Yes.
can it be taken up on 29th?
29.
This matter of eviction.
Okay, under prayer of Mr. T. Patil, learned counsel for the petitioner, release the case on 29.
Obliged.
Lordship, item number 16. I'm appearing for respondent number 2 entry on behalf of El Parme.
El Parme,
Yes. Standing
Yes.
Council for Agriculture Department.
Standing Council, Agriculture Department.
Yes. This may be,
Parme is Agriculture Department.
yes,
Okay, yes.
it may be taken
You are for the petitioner?
Yes, Lordship.
Yes.
after 3.
After 3 weeks?
Yes, Lordship.
Lordship, entry may be continue.
Okay. Mr.
B. Sivo on behalf of T. Tapak.
Okay, for the petitioner is present, a prayer is made, prayer for adjournment is made by Mr. Swain, so on behalf of Mr. L. Parmel and Standing Council, Agriculture Department. First of all, as the prayer is not opposed by the learned counsel for the petitioner, please the case come as sought for, after 3 weeks on a day 2 weeks by the office.
Lordship, entry may be continue.
At the interim of the past secretary shall continue till
My Lordship, I beg to mention item number 17.
17.
Yes, Lordship. On behalf of M. Kato, Lordship.
Okay, he is absent.
Lordship, he has some personal difficulties.
Okay, Miss
Vaigao, Lordship.
learned counsel, on behalf of the learned Deputy Solicitor General of India, for the petitioner has made a prayer for adjournment. So it is submitted that counsel has been taken from the learned counsel for the respondents to make the prayer.
And
First
Lordship, in this matter,
The
fixed date may
list
be
the case
given, Lordship.
after,
6 May. Fixed date may be given, Lordship.
this is the case on 6/5.
And Lordship, there's an interim.
In arbitration appeal,
Yes,
okay,
Lordship.
arbitration appeal, the interim order passed earlier. Check, huh? Shall
Obliged,
continue till the next date of listing.
Obliged, Lordship.
My lord, item number 9 has been mentioned with my consent, my lord. Only my presence may be noted.
Okay, 9, huh? Item number, Mr. B.K. Singh, Standing Counsel, FCI, is present.
My item number 1 was there, my lord. Item number 1 was there in the other court, my lord. That's why I was not present. Highly obliged, my lord.
Item number 1.
Yes.
Please, my lord. My lord, this contempt petition has been filed for non-compliance of the order dated 17/3/2026 in WPC number 100. My lord, the operating person of the order is in the page number 17, my lord.
We have to dispose of the representation.
My lord, 17, my lord.
After affording an opportunity of hearing.
My lord.
Hearing was given or not?
No, my lord.
Not given.
Even the attempt has not been made by this contempt, my lord.
Okay.
So, my lord, this is the notice my wish.
Heard Mr.
Shimoli.
Learned counsel for the petitioner. This contempt petition is filed stating that there is no non-compliance of the direction made in an order dated 17/3/2026, passed in a petition WPC number 100/2026. It is averred that the order dated 17/3/2026 was duly brought to the notice of the respondent, sole respondent,
on 23.
on 23 03/2026. Post of. The direction to the respondent was to dispose of a representation, stated to have been filed by the petitioner, after affording an opportunity of hearing to all the concerned parties, and thereafter to pass a speaking order. Post of. Issue notice returnable on so and so. The petitioner shall take steps for service of notice upon the respondent by speed post within 3 working days from today.
Obliged, ma'am.
Item number 4.
May I please, Your Lordship?
Yes.
By filing this writ petition, I am praying before this honorable court to quash the impugned order dated 12/7/2022, page 42, my lord.
12/7/2000, page 42.
This is. Yeah.
Yes.
My lord, for this order, I am being superseded because I am the senior cadre in the department than the private respondent number. This is private respondent number 4. So,
Private respondent.
private respondent number 4.
Private respondent number 6.
6, no? 6, my lord. Private
Six.
respondent number 6, yes.
How you are superseded?
Because I am the regular and permanent employee of TPN ULB, Town Planning and Urban Local Body. Now it is separated as Urban Local Body. And through DPC, I have been regularized in the year 2017. But the private respondent is shortly absorbed in the department.
Is it by way of appointment or by way of deputation?
By way of, I'm not deportation, but he is deportation, on deportation.
He is on deputation?
Yes, I'm regular. So I should have been elevated to the post.
Now, what is the post?
It is an
Municipal Executive Engineer.
Yes.
What is PMC stands for?
Pasighat. Pasighat Municipal Corporation.
Pasighat Municipal Corporation.
Council.
Municipal
Council.
Municipal Council.
Yes.
Point Sukia Pordung. Department of Rural Development. So he is from Rural Development Department.
Yes. His parent department is Rural Development Department.
My brother, he informed the main respondent, the standing council is not there, man.
Who are the standing council? Rural Development and Municipal, both should be.
Main municipal, because he is the employment is under.
Yes.
And my brother, he just informed that the standing council is not there.
Oh.
Otherwise,
Who is the standing council?
Mr. Tapi Omo.
Your Lordship, on behalf of Standing Council, Mr. Tapi Omo, Your Lordship.
Oh.
Otherwise,
We're seeking for adjournment, Your Lordship.
Yes, Mr. Dekka.
Yes.
We'll be relying on the affidavit of respondent 1 and 2, Your Lordship.
My lord,
Then he is in best position to explain.
yes. So in the department,
So no point proceeding further. Mr. U. Dekka, Learned Counsel for the petitioner. Mr. You are for,
Sir, you are
who is the State Council?
I am for the RD.
Mr. B. Picha.
For respondent number 4 and 5.
Okay, Learned Counsel for the respondent number 4 and 5.
Yes.
You are standing counsel rural development?
Yes, ma'am.
Okay, rural development. 4 and 5, Mr. R.X. Nama.
My lord. For
And additional AG. 1?
1 and 2, my lord.
1 and 2.
Yes.
So 3 is missing.
3 is missing.
Okay.
And-
And Mr. Your name, please.
Ruling, Your Lordship. On behalf of
On behalf of Mr.
TMO, Your Lordship.
Line Standing Council.
Respondent number 3.
Line Standing Council. What is the department?
Urban local bodies.
Urban Local Bodies Department. And who is for respondent number 6?
I'm for the respondent.
Okay. Mr. P.
Peter.
Tapo, Learned Counsel for the respondent number 6 are present. Those are Mr. So-and-so, Learned Counsel, appearing on behalf of Mr. So-and-so, Learned Standing Council, Urban Local Bodies for the respondent number 3 has submitted that Mr. So-and-so, Learned Standing Council, ULB department is out of station due to personal reasons. First off, he has made a prayer for adjournment. First off, when he will be able to come? After what? What is the time period you want? What is the time period you want?
2 weeks, Your Lordship.
2 weeks. Okay, as sought for by the Learned Counsel for the respondent number 3 and as agreed to by the Learned Counsel for the other side. Release the case. Any interim order?
No, there was no interim order, my lord.
Then 2023 it is. Release the case after 2 weeks on a date to be fixed by the office.
Obliged.
Obliged.
Item number 6.
Aye.
May I please, Your Lordship?
Yes.
Yes. Madam, in this matter, madam, if Your Lordship is ready to dispose of the matter, then we are ready to.
I don't know. I'm
Otherwise,
in a bit of discomfort because of heavy lower back pain.
Yes.
What is the matter about?
Madam, matter related to compassionate appointment, madam.
Compassionate appointment?
Yes, madam. So what happened is that in this matter, there is a 2 OM. One is of 2001 and another is of 2002. And the procedure is both are same. But what they have done is that all the petitioners they have short for the applications, and then they have
How many petitioners?
67 petitioners, madam.
Huh?
67.
67.
60, sorry. They have filed the application for the compassionate appointment in under 201 compassionate schemes.
No, how it is a common cause of action first. Tell me.
Yes.
For 67 petitioners, how it is a common cause of action?
No, they have different. All are applicant for the
Just
compassionate.
because all are applicants.
Yes, madam.
Right. Their age range from what? And the person on whom they were dependent.
Yes, madam.
They expired on different dates.
Different dates, madam.
You applied on different dates.
Different dates, madam.
Right?
Yes, madam.
Gap may be different.
Yes, madam. That's.
How can we examine the cases of all the petitioners, 68 petitioners, it's a common cause of action? What is the common cause of action?
Madam,
Is it a common, is it a case, it is a pleaded case that you have a common cause of action?
No, my lord, what we have pleaded is that we have filed an application for the consideration under the compassionate schemes of 2001. But then what they have done is that without following the schemes, procedures, what they have opted is that the examination. One is the first is the physical test, standard physical test, eligibility test, and another is the examination. Examination that also includes physics, chemistry, my lord. Whereas as for the 2 OAM, one of 2001, under which they have applied, all the applicants, my lord, all the petitioners, and another is of 2002, is a condition is almost same, procedure is almost same. There is no any procedure for the any written examination, no physical test. The procedures are not in that OM, but then they have opted is that they should go through the physical test first, and then they have to go through the
Any department?
in the police department.
Or police department?
Yes, my lord.
Where fitness is utmost essential.
But then
it may not be physics, chemistry, but that is a different, I will see. But physical fitness is there.
The physical test, my lord, once they are considered by the authority, then they have to go to the medical test and everything they have been following. That we are not disputing, they have been following. But then here, as for the new OAM of 2022, which is they have adopted in 2020 new OAM, my lord, they have adapted the examination process. That's what we are challenging on that ground only, my lord.
Just a minute.
Yes, my lord. So we are praying that petitioners who are before your court, they should be considered as per the OAM of 2001, if not in 2002.
Just a minute, just a minute.
Yeah.
What are those impugn notices?
Yes, impugn notice, one is, my lord, in page 31 and page 31, my lord. 31 and 35. Page 31 is annexure 1. This is notice for the written examination, my lord. And you Lord may see the subjects. This is other compassion appointment, but then it's this impugn notice for the written examination clearly shows that it is a regular recruitment process, my lord. May I read, my lord? Written examination for 35 various posts under the compassionate ground in the Arunachal Pradesh Police is scheduled to be held on 13 and 14 September at VKB School, PTC Bandedova and trade test on 15/25 PTC Bandedova, details enclosed in annexure. Candidates advised to the Lord such and such. 3, my lord, the post-wise vacancies require education qualifications. Schemes of written examination is shown under the table below as existing recruitment rules. As existing recruitment rules, my lord. Whereas as per the compassionate ground, recruitment rule is not to be followed, my lord. One is a head constable. Second, serial number 2 is a constable. 3 is a constable band. 4 is a constable bugler.
Say head constable, civil police.
Yes,
Post.
civil police. Yes.
The educational qualification is the essential one. Which
There is no issue, no essential one. But a written test, my lord, may see that general English, general knowledge, maths, physics, chemistry, my lord. And 2 constable, general English, general knowledge, elementary mathematics. And then constable
basically your grievance is that holding of the written test.
Yes, my lord. I mean, written cannot be
written examination
cannot be conducted to appoint the petitioners or for consideration under the compassionate ground. They cannot follow the written examination process, my lord. I'll just I will show you the.
Where is the scheme under?
Yes, my lord. I will come to that scheme, my lord. Scheme is page 51. Is a old scheme. I will take to two schemes. One is of 2021. Is page 51. Is a type copy, my lord. Type copy page. It starts from page 51. The relevant one I will take to is a section 5. Page 52. You also may see page 52. Last one. Eligibility. Married at 1. A. Family is indigent and deserve immediate assistance for relief from the financial institution. And B. Applicant for the compassionate appointment should be eligible and suitable for the post in all respects. Under the provisions of relevant recruitment rules. We are not disputing, my lord. Under the relevance of recruitment rule, that is the clause, my lord. And another, my lord, I will take to another is section 12, my lord. That is important, my lord. Section 12. Section 12 talks about the procedure for the appointment under the compassionate ground, my lord. Yes, my lord. 12A, B, C, my lord, I may just start from A. Performer as an annexure may be used for the ministry department office for the ascertaining necessary informations. And welfare officer is important, my lord. In the each ministry department office should meet the members of the family of the government servants in question immediately after his date to advise and assist them in getting appointment on the compassionate grounds. The applicant should be called in person at the very first stage and advised in person about the requirement or formalities to be completed by him. C. Application for appointment on the compassionate ground should be considered in the light of the instruction issued from time to time by the Department Personnel Administrative Reform and Training on the subject by a committee of officers. Consider important is the committee has to be there, my lord. Committee of the officers consisting of 3 officers, 1 chairman and 2 members in the rank of joint secretary or deputy secretary in the ministry or department. The welfare officer may also be taken as one of the members, chairmen of the committee. Depending upon his rank, the committee may meet during the second week of every month to consider cases received during the previous month. The applicant may also be granted personal hearing by committee if necessary for a better appreciation of the facts of the case. D, my lord. After this, my lord, the committee has to consider the the scoring parameters, my lord. That is the financial institution, my lord. Now the last the part is that recommendation of the committee should be placed before the competent authority for the decision. If the competent authority disagrees with the committee's recommendation, the case may be referred to the next higher authority for the decision. So this is the all OAM alert. Now I can also take to the new OAM 2022.
Yes.
It has a detailed description alert. They have modified, they have amended in the OAM, and the state government they are submitting that we are adopting that new OAM. So even in new OAM also, there is no provision for any examinations, my lord. I will take to that new one also.
Yes, which page?
So I will take to a new OAM alert. My new OAM is page 64, my lord. Page 64, my lord. Page 64, my lord. Yes, 64. Page 64 and relevant paragraph is in page 67, my lord. 67, my lord. Last paragraph, my lord. 67, last one. Eligibility, my lord. May I read that one? This is a new OM, my lord. The family is indigent and deserve immediate assistance for the relief from the financial institution. And application for compensation appointment should be eligible and suitable for the post in all respect under the provisions of relevant recruitment rule. This is same thing, Balaji. You also have seen the old one also. In a new also, it is the same, the clause mentioned, 5B. Now, I will take to the exemption, my lord. It's in 68, my lord. Your lordship may see the exemption, my lord. Why this recruitment, this examination process should not be allowed, should not be conducted. Page 68, my lord. 68, section 6A, exemption, my lord. Compassionate appointments are exempted from observance of the following requirements. 1A, recruitment procedure without the agency of the staff selection committee or the employment exchange. B, clearance from the surplus of sale of the Department of Personnel and Training, Director General of Employment or Training. C, the ban order on filling out a post issued by the Ministry of Finance Department of Expenditure. So this is the exemption. The A will be relevant, my lord. Recruitment procedure without the agency of instruction commission of the employment exchange. Now I will take to the relevant procedures, my lord. That is important. Your lordship may see the how the procedure has to follow. That is the point. That is called. I will just take to that. That is called point-based merit system, my lord. Has to be followed. I will take to my lord. It's in page. Page 73, section 13, my lord. My lord. Section 13 procedure. I will just read only relevant provisions. Roman subclause 6. The lordship may say subclause 6. Every application to be in order should be acknowledged by the assigning a unique registration number. All pending applications should also be assigned a unique registration number and has number. This may be done within 2 or 3 weeks of a time. Once a unique registration number has been assigned to an application, the applicant, including those whose applications are pending, may be informed through email or order forms of a communication, including digital modes of communication of their unique application registration. That is how they have to do. And now, my lord, 5 will be the.
We have read 5.
Oh, 5. I have read 5. Yes, my lord. I will read 7, my lord. I will read 7. 6, 7. I will read 7, my lord. While informing the application of the registration number of their application, they may also be informed of
the likely number of vacancies likely to be available to be filled on compensation ground, as well as provided with a copy of point-based merit system, my lord. That is a very important point here, point-based merit system, my lord. And then next I will read 8. To consider the various, my lord, that's important, my lord. To consider the various applications and to recommend the individual applicant for grant of compassionate appointment, a committee, my lord, that's important, my lord. Committee comprising 3 members, 1 chairman and 2 members may be constituted. The committee may also be chaired by an officer not below the rank of director or deputy director in the ministry department, and officers of the equivalent rank in the case of the attached and subordinate officer, my lord. So next relevant will be, I will read 10, my lord. 10, my lord.
Yes.
Prior to every meeting of a committee, the applicants whose applications are being considered should be informed through email or other form of communication, including digital mode of communication, of the numbers of the vacancies in each grade for which they are being considered. Also, the date of the committee is due to meet to consider their application, my lord. However, the applicant would not be required to have any personal interactions either with the administration or the committee, that the application may not be asked to be present during the meeting of the committee, my lord. Now I will read 11, my lord. Every ballot application should be assessed strictly, my lord, that is strictly on the basis of the point-based merit system. That's a very important, my lord. Point-based merit system, not the recruitment process, my lord. So formulated by the concerned administrative ministry department, my lord.
Now, what is their answer?
Yes, my lord.
All posts are in police department.
All police department.
All posts, the notice was which page?
Yes, my lord.
The notice, impugn notice is at which page?
In the impugn notice, my lord, is in page 31, my lord. Impugn notice is 104, my lord.
First, this one, page 31 is?
First, 31 is impugned.
What is some interim order?
Yes.
On vacation, right?
I can just take to that various annexures, my lord. Annexures.
Just a minute, let me understand. So, was there any interim order?
Yes, boss. Not to declare the result, boss.
Yes.
But the conducting the written examination, it was allowed by this one, but not to declare the result without permissions of this one.
Okay. Was there interim order?
Now, in this matter, your lordship has to see is that whether it can be allowed or not, my lord. That is the.
What is the reason they have given for holding this?
Yes, as per the affidavit, they are saying that new OM has come. So as per new OM, it says that recruitment rule has to be followed.
What is that OM?
That's what OM, that's new OM alert. Just OM that alert. I'll take to the new OM alert. As in page. It's in page 64. New OM is in page 64. And then section 5, that is eligible mallet. I will just take back to the eligible mallet. Is in page 67 mallet. Page 67, last eligibility. So in eligibility 5, subclause B, mallet. You'll notice when I say that subclause B, applicant for the compassion appointment should be eligible and suitable for the post in all respect under the provision of relevant recruitment rules. Only the applicant has to be eligible, mallet. It doesn't say, it doesn't talks about, mallet, that recruitment rule has to be followed, because section 6.
All these eligibility are to be read together.
Yes, mallet.
For company should be eligible.
Yes, mallet.
One is by qualification.
Yes.
Then one has to be suitable.
Yes, mallet. Yes, mallet.
For the post.
Yes, mallet.
Say for police, you need some suitability.
Suitability, that's there.
Otherwise, say post one is blind of one eye.
Yes, mallet.
Police here the strict physical standards are to be maintained. Police less.
Yes.
If it is advertised, suppose 2 posts for open category, there will be 10,000 candidates. But if it is reserved for compassionate appointment out of the 5%, there will be very less, say 200 candidates.
Yes.
First, one has to fulfill the A. That family deserves immediate assistance. Right.
Yes,
That
yes.
is the whole purpose of compassion.
Compassion appointment. Yeah, exactly.
Right.
Yes.
So after that, suppose the department finds there are 100 who deserves immediate
financial assistance. Yes.
But post available is say 5.
Yes.
Then how to do it? It will be a subjective or what? At least the suitability is to be there.
Yes, that's called, my lord, that's called point-based system. Point-based merit system.
What is that point-based merit?
Point-based merit system, my lord. They have to consider is that family pension and terminal benefits, monthly income, movable, immovable properties, leftover resources, dependents. So all the family condition has to be assessed by the committee, my lord. And then they have to make most eligible first and second, third, fourth, fifth, as per the economic condition of the family. So this is the that's called point-based merit system. That is the only way to select the.
Where it is?
That's my lord. I have already read, my lord, as per the procedure, my lord. That is in, my lord, page 73. 73. Page 73, my lord.
Where it is mentioned?
Mentioned, my lord. I have just read point-based system, my lord. Yes, my lord. 7, my lord. 7, may I read, my lord? While informing the applicant of the registration number of their application, they may also be informed of the likely numbers of vacancies likely to be available to be filled on compassionate ground, as well as to be provided the copy of the point-based merit system.
Where is that point-based merit system?
Point-based merit system, my lord, that has to be, my lord, on the basis of application, the committee has to.
No. Point-based merit system means it indicates about some objective standard.
Yes.
Right. Where is that merit system?
My lord, the standard is, my lord, indigent and
No, there must be point-based merit system. There must be, say, maximum 10.
Yes.
Right. Say if a family has from all its sources only 2,000 income per month, then he will be given more priority.
Priority, right.
Right? A person having 10,000 income per month.
Yes.
He'll be given lesser marks.
Lesser marks.
Where is the point-based merit system?
My lord,
Yes, Mr. Where is the point-based merit system?
Lordship, this, if Lordship see this very particular clause, Lordship, that is page 73, Lordship. What it says, Lordship? It says that some department, clause 6, Lordship.
Some department.
Some department, Lordship. Such as so and so have devised their own point-based merit system for processing claims for compassionate appointment, Lordship.
Right, police is there or not?
Lordship, it says that some department have they have formulated their own lordship that system lordship.
Police,
but not all the departments.
whether police has or not.
Here lordship, our department have not formulated that lordship system lordship.
Then you devise for written examination.
That's what they are doing, my lord.
Here what happened lordship? Basically, when we see the scheme lordship, this is immediate lordship. And that is
the I have heard. Service jurisprudence, right? It is exception to Article 14.
Correct.
Yes, sir.
And 16.
Lost.
And again, within the exception, now you have again introduced elements of Article 14 and 16.
16.
By putting some written examination, physical test. Yes, physical test may be required in police department.
The fact and circumstances lordship. How lordship we have handled this lordship. As I understood, as I have submitted lordship, as per this scheme lordship, the immediate assistance is required.
That is the
but that is always subject to availability of the post lordship.
Right.
What happened in this case lordship? There are many applicants lordship.
Right, that is what
and posts were not available at that point of time lordship. And they have already passed through that lordship, the crisis period lordship.
That I have understood. I am trying to find out that page 67, eligibility.
Lordship.
Whether you have screened the candidates
Lordship.
In the context of clause 5A.
Yes, yes.
That they need immediate financial assistance. Otherwise, there may be 10 candidates, one post.
No, sir.
Normal concept I have understood is that who needs financial assistance, who is the most deserving candidate out of them. That is the way. Firstly, how much income after the demise of the earning member, whether there was any earning member or not. If not, how much the family earns by way of, say, cultivation, whatever. Right. So, if out of 10 candidates, the family income is 1,000 to 10,000, the person with 1,000 will be given priority. But in the meantime, if he has the demise took place 10 years earlier, then again he will be relegated to the back. Because if he has spent 10 years without the earning member, so priority is gone.
Correct.
Right. So how you have introduced that? This is beyond my
Lordship, as I have said,
normal understanding.
Because that immediate assistance lordship, that period has already passed lordship in respect of all the petitioners lordship. Now when this when vacancy arose lordship, now question posed before the department lordship. Now how their cases are to be considered lordship. Then lordship,
if they have passed the years,
lordship,
they are to be thrown out.
But even
by that recent judgment, what is that judgment? Why Justice Dipankar Datta? What is that judgment, madam? A recent judgment? Not recent. About 1 or 2 years back. Debabrata.
By lapse of time, lordship.
Some Debabrata something.
Correct, lordship.
No. That is why my first query to the petitioners' council was that how it could be a common action. Each case has to be judged on its own terms, each applicant's case. But he has posed this question, how this compassionate appointment, in a matter of compassionate appointment, examination. Firstly, compassionate appointment is exception to Article 14 and 16. Meaning thereby normal rigors of recruitment procedure are to be done away with. And the person who is most deserving is to be chosen out of many. Right?
Correct.
And there are, in course of time, a number of principles have emerged that if, say, the family has managed to, say, tide over the financial crisis, then there is no need of compassionate appointment.
Already out.
Right. Now, this is an exception.
Direct loss.
But again, you have introduced elements of Article 14 and 16 here. This is what is beyond my comprehension.
Lordship, that's the leniency on the part of the department, Lordship. Since all of them are applicants.
No, how can it be?
When posts are there, Lordship, then we have given opportunity to all the applicants.
How can it be?
And even the petitioner, in terms of these very notifications, where it says, Lordship, you have to pass through the physical test and then written test. In terms of that very notification, even the petition, they appear in the physical test, Lordship. They have attended.
From the scheme, it is not there that there will be examination.
Yes.
In specific terms. In the scheme. Page 67, now you have introduced this written examination perhaps by clause 5B.
Correct, Lordship.
Right?
Yes.
Otherwise, if you look at
the inter scheme,
look at the address scheme, there is no mention about any screening examination, or even if we take it as a screening examination.
Correct, Lordship.
It is not there. But you have read this written examination, physical examination, that too, by physics, chemistry and all, right, into this clause 5B.
Lordship. That is correct, Lordship. But one thing, Lordship, if Lordship see the procedure, Lordship, that is given under clause 13, Lordship, it is not exhaustive in nature, Lordship.
Right.
Because so far the
everybody knows that vacancies under compassionate appointment is limited to 5%. I think 5%?
Yes.
5%.
5%.
5%.
Meaning thereby it is scarce. Very limited. And it will arise only, say, in a year, 5, 10, 15. Police force is a large force, so maybe 100. But seeking compassionate appointment, number of candidates will be 1,000. And out of that, the scheme normally envisages that most deserving candidates from the terms of financial needs are to be appointed in the absence of the earning member of the family. So where this concept is introduced, that is that examination concept is introduced. But first priority is financial needs. If a family has a widow and say 2 children of say 2 years and 4 years, another family having the widow of 55 years and 3 sons having ages of 30 and 25, which family need more financial assistance? Obviously family 1, not family 2. Those are the standards, I think.
Yes.
Yes.
How now these two you put in an examination?
Yes.
The widow from the first family and the
second
25 years or 30 years son from the second family, written examination. I think this is something I have never come across. It needs some, Mr. I need some more research into the concept. This is alien to, it looks like alien
Yes,
to
yes, my lord.
the concept of compassion.
Exactly.
That is correct, Lordship. But here, Lord Department, under that peculiar circumstance, Lordship.
Cannot be peculiar.
When there's no immediate applicant, Lordship. No immediate applicant, Lordship.
No, this is not the case. Is it the case?
No, this is not the case.
If there is no immediate need, throw them all out by passing speaking order.
No, sir.
Is it not?
Yes.
If there is no immediate need, throw all of them out.
Correct.
Pass a speaking order. This family has enough financial resources to tide over the crisis. No necessity of compassion on the pen. Throw them out. But you say no immediate necessity, come all, participate in the competitive examination.
But limited department.
But that is limited. This concept is exception to Article 14 and 16. Then again, you have introduced Article 14 and 16. Say, if those posts are advertised, there will be 1 lakh candidate. Now, you have reduced because it is 5% out of 100%. So you have taken it and introduced them to rigors of again written examination, physical tests and all. So this is making beneficial to them because of their fortuitous circumstances. But that is not the concept, I think, compassionate.
Yes, sir.
Compassionate is immediate need because family is going to starve. Suppose if the family, I have given the example of family A and B, the committee has to examine that aspect. That this family needs immediate. So one person should be appointed from that. But you have introduced making them equal, make them participate in a written examination, and whoever emerges first on merit.
They will go.
You have introduced the concept of merit again. Suitability, all. This concept has come for the first time. I'm doing some introspection from my side also. Mr. Some more.
Well, last time also, when your lordship was asked my brother saying that, why don't you talk to a department? Why we don't go review the matters?
It needs some the whole concept has been changed. If a person does not need any financial risk, then throw him out, reject his case. He may come in a writ petition, that is a different matter.
Yes, madam.
That court is in a position to tackle. But this again, introduction of element of Article 14 and 16 in compassion and appointment. Supreme Court has time and again held that this is not to be resorted to normally, but however, an exception is carved out of Article 14 and 16. But by this written examination and physical test, you have introduced again. It is beyond my thinking.
Keeping aside the merit of the case, Lordship, on technicality, if Lordship come to the page 149, Lordship. This is a notice, Lordship, on the basis of which, Lordship, this selection procedure is started, Lordship. Here it talks about the Lordship physical test. If you qualify in the physical test, the next stage is the written examination, Lordship. This notice, Lordship.
Right, that is what.
Now my question on technicality, Lordship. This very notice is not under challenge. They have participated in the process, Lordship. Out of 67 petitioner, Lordship, 54, they have been disqualified in the physical test, Lordship. Only writ petition number 1, 2, 3, they qualify in the physical test, Lordship.
This after this 8 June 2024, 54 of them participated.
No, all of them participated.
All of them.
No, not all of them. Around. This what he referring is the last advertisement. There is one more advertisement all have participated, they had listed out, my lord. I can just show the list of all the petitioners in the first list as per 2001 OAM.
No, here we are part of, in this requisition, this 8 June 2024.
Yes.
Right.
Yes, my lord.
35 vacancies, right?
Yes, my lord.
Applied for compassionate government, all applicants. You please come and participate, right? This is the notice. Then cut-off date. The applicants are directed to produce certificates. Okay, those are correct because you have to fulfill the eligibility criteria. Then date of PST has been fixed on 26/6. PST means physical test. And those qualifying in PST or PET there will be written test, right?
Yes.
So you appear in the PST.
Some of them, they have appeared, my lord. And
How many?
My lord, around. But 3 are in the list of the result which we are challenging. 2 petitioners are in the list, my lord.
No. How many appeared in the PST?
My lord, I think not all, but then some have appeared, my lord. That's there, my lord. But then, my lord, issue is, my lord, when the scheme has to be implemented, when the action taken contrary to the governing scheme.
That concept it is very alien to me.
Yes.
I have not come across this kind of.
When action is contrary to the governing scheme, it's a void, my lord. It's a void. The way they have conducted, they cannot conduct the written examination. Now they cannot say that you have contested and then you cannot again challenge the matter. That is, I think, is illogical stand of the respondents, my lord. The conduct the action, because the issue here is the implementation of the scheme.
Is there any authority?
Yes.
Is there any authority?
Authority has, my lord, yes, my lord. My lord,
Specific.
in the case
like
of
the case in hand.
Yes, my lord, I have said, my lord.
Like the specific, like the case in hand.
Yes, I have. Yes, I mean.
Any introduction of written examination among the applicants?
Don't
give. What is the concept of completion appointment? Somewhat akin to the facts and circumstances of this case.
Otherwise, my lord.
That all the compassionate appointment candidates are put on a common test like that.
My lord, I have one judgment which talks about, my lord, talks about, my lord, one is that they cannot.
Lordship, I have 2 citation, Lordship. One says, Lordship, so far the armed forces and police personnel are concerned. Physical test, you have to have the standard, Lordship. That is one, Lordship. And second citation, it says, Lordship, after you have participated in the selection process.
And that is the law.
Here, Lordship.
After you have that is why I have asked you about the specific number of candidates.
Lordship. As per my information, Lordship, all of them participated in the.
All of them.
All of them.
Then it is gone.
That's my result.
Then they cannot blow hot and cold at the same time.
That's my.
Once notice has been issued, it should have been challenged. They should not have participated there. Because to ask them,
well, I just checked to the.
All of them have failed in the PST.
Well, no, that is not the case.
Them, they qualified. 3 of them. Read petition number 1, 2, and 3. They qualified in the physical test laws.
Yes, Sabas.
And they have been shortlisted.
Yes, some are successful in that result.
They have been shortlisted for written examination and they have participated in the written examination.
So this challenge should be limited to 1 to 3.
Well,
you don't have the physical this thing.
Well, I'll just.
Out of these applicants, only 3 have satisfied. Height,
and these 3 too, they participate in the written examination, Lordship. And result is ready for declarations because interim order is here, Lordship. Therefore, we have not.
I will just take to. Otherwise, any compassionate appointment,
right, but everything is peculiar facts and circumstances
Yes,
of the
my lord.
case. Now, one law is there that when with your eyes open, you participated in a process, and after you turn out to be unsuccessful, you cannot say that grape is sour. Grape is sour. Right? If out of 68, all of them participated, and for the physical test, not written, then only 3 are fit enough to join police force. All are police force.
Yes, all are police force.
All vacancies are police force.
Yes, my lord.
That must be, that attribute must be their physical attribute. So only 3 of them have passed. Right?
But then, my lord,
1 minute,
Yes,
let me complete. And thereafter, they also appeared, these 3 appeared in a written examination. If this is the fact, 1, 2, and 3, they have also appeared in the written examination prior to filing the writ petition or after filing the writ petition.
So for physical test is concerned prior to filing of the
writ petition.
But the examination, written examination is after filing of the writ.
my lord, in fact, my lord,
Get the facts clear, whether it is correct or not. Otherwise,
my lord,
1, 2, 3, I'll make it limited. Keeping the introduction of written examination at a later point of time. Yes, still 1 to 3 is challenge to the written examination because court has observed without prejudice to their rights in the interim order.
but then, my lord,
So 1 to 3 challenge will remain, but so far as this blowing hot and cold at the same time is not.
my lord, but then, my lord, when this,
Mr. Can you have you made the statements in the affidavit?
Lordship, in my affidavit, that is because the amendment is not there, Lordship. But in my IA, Lordship, because I have filed on IA, that's
for what?
6 for modifications to interim order, because we want to declare the result, but since interim order is there, Lordship. There, I have made a categorical statement that look, they have participated in the physical test, and in reply to that, they have not denied loss.
No, they have participated in the physical test.
Physical test loss. And they have not denied that very statement in their reply to my IA loss.
no, some have participated, but I'm sure we are also sure that
question is still there. How you have introduced this system?
because they are supposed
yes. You have to shortlist the deserving candidates.
Yes, my lord.
But you have, after that deserving candidates, marks are same in the merit base or whatever. Then you can put the 2 of them in the test. Whoever has better qualification, he is to be.
So,
but then they have to be same parameter, my lord.
This case can be limited to these 3 lawsuits.
That I have to see.
Because race lawsuit, as I have said, lawsuit, just citation lawsuit, physical standard, they have to satisfy that physical standard so for armed personnel and police.
Which one? Rajkumar.
No, this is a lawsuit.
That Rajkumar is different.
No.
Once you have
Here,
participated.
Physical test lawsuit.
Let's see, madam.
This Allahabad High Court. Yeah, but lawsuit, out of 67 lawsuit, only 3% they qualify in the physical test lawsuit. कितना पैराग्राफ में
दे दिया हूँ ये ना
चैलेंज करके फिजिकल पूरे चलेंगे पूछते थे इसका वो विड्रॉ कर
वो तो फिर वो that will much better.
Do you have the results of the physical test?
No.
Can you produce?
No. Physical test. That notification is here also. Result notification is annexed in the writ petition.
We also challenge that one, my lord. Annexion 1, my lord. Annexion 1, my lord.
Page 35 laws of the writ petition. this real notification also is being challenged by the writ petitioner, where lordship they have been they have been found qualified for the written examination lordship.
They have
this is
when things are supposed to be done that way, they have not done that way. I don't, my lord, it can be not be correct arguing that.
No.
They can.
Once you have participated with your eyes open, you cannot challenge, you cannot turn back and say that this is bad.
My lord, thing is, my lord, I will just maybe.
And compassionate appointment is not a matter of right.
Yes, that is there, my lord.
That is a law.
I will just, I have one citation, my lord, of 1997, my lord. In this case, the estoppel will not apply even if he was successful in the examination, my lord. If the procedure is...
That you will rely on that paragraph so-and-so of Rajkumar.
Yes, my lord.
I know.
Rajkumar, yes, and Sakti Raj.
I know.
Yes, paragraph 16, my lord. Similar case, my lord.
One particular paragraph is there,
yes,
Rajkumar.
Yes, my lord. So when the whole procedure is wrong, my lord, your lordship have already seen that...
Every case is to be on the facts of the principle is there.
The scheme doesn't contain the examination process, my lord. That has to be considered, your lordship, my lord.
No, but we have participated. Why you have participated?
No,
the normal course is to not to participate and to challenge.
But my lord, they are all widows, my lord. They don't know. I mean, legal procedures, my lord. Maybe they are saying that you have to. That is there, my lord. In the case of this widows, they are all illiterates. So, and I mean, not much well educated. Maybe some people that participate. That is the issue.
How many are widows?
So, my lord, petitioners.
I don't find many. Maybe 30%. But if they are not fit enough, fitness must be required. Police.
Yes, fit.
They are not fit enough. No point pursuing against those vacancies. Firstly, you have to see all points, Mr. Counsel. If you don't have the physical attributes to be appointed in the police force, in the vacancies advertised.
Yes, my lord.
It is already found out, and that is a requirement. So they go. Otherwise, they cannot pursue against these advertisements, notice, because they don't have the physical. It is already emerged. It is a fate established that petition number 4267 do not have the physical attributes to join the police force. Right. No point for them to pursue this litigation because these notices are specific to vacancies in a police force. That will not extinguish your right to pursue your corporation appointment in other vacancies. Right?
MTSL.
That I can observe. But when you do not have the physical fitness or attributes, how can you pursue this writ petition? Because the end result is that you are never going to be appointed in a police force for these posts.
But by the my lord,
petition number 42 remain. 1 to 3 is a different matter. Their challenge to the written examination notice is a different matter. But so far as these petition number 4 to petition number 68, they don't have the physical fitness or attributes to join the vacancies advertised. So what is their right to pursue this writ petition further? Tell me. At the end result is what? Operation successful, patient dead. They are never going to be appointed in these vacancies.
My lord.
But their rights
Good, I can preserve your right for other vacancies, but police vacancies, these are advertised, page 31. All these, you don't have the attribute.
My lord, thing is, my lord, maybe one petitioner or two petitioner, when
Then I can ask the standing council to give the result in a seal cover. I find out whether 1, 2, 3 has passed the examination. If they have passed the examination, end of the matter.
my lord,
they may have passed also.
My lord, thing is that, my lord,
if they have passed, then 4 to 68, they have no case.
No case.
And petitioner 1, 2, 3, if they have passed, end of the.
They themselves they will withdraw.
My lord, in fact, thing is, my lord, we are harping on the scheme, my lord.
Scheme you can find out later on, but so far as 4 to 68,
yes,
they are out of these vacancies.
No, even if one is
for 1 to 3, yes, we can examine, and that larger issue, this exception out of exception, whether that can be tested in a different manner. But if in the meantime 1 to 3 have passed the exam, just a minute.
Yes, my lord.
Just a minute. Then they would not have any grievance. They would not have any grievance. If they pass if they do not pass, they can still pursue the writ.
But my lord, I just want to submit is that, my lord, as per the scheme, my lord,
and will not do academic exercise.
My lord, as per the scheme, my lord, committee has to be there, my lord. Committee has to decide the parameters, but not through the examination process, my lord.
Mr. Council, many things to decide a list, right? One of the ways out is this. This can be tested if similar kind of exercise is done in future. This can be definitely tested, right? So far as on date, 4 to 68 is out for these vacancies, but that will not preclude them to claim appointment in other vacancies. For police vacancies, they are out.
My lord, my submission.
One has to be also on facts, not on law.
Yes, my lord. But my submission would be that when the scheme doesn't provide for the examination, how they can scrutinize through the examination, my lord. That your lordship has to see, my lord. Whether even one petition.
I can rely on this Allahabad High Court judgment that for police post, physical examination has to be there for even in compassionate appointment. Then all are
that is
all
okay.
are out. You have participated, all are out.
But that is okay. But then written examination, my lord, how they can conduct, my lord. Even if one is challenging, my lord, even if one petition is challenging this impugned order, saying that you cannot conduct
further examination.
More law just sound like.
If they cannot conduct the written examination, they cannot follow, my lord.
Apart from
when the examination process is
I have understood your case.
Yes,
sir.
yes,
I am trying to find out the ways and means.
Yes, my lord. When it is contrary to the scheme, my lord, it is a void process, my lord. This is a void.
Kindly come to paragraph 22, lordship. This is on this very
and all are widows, and then even they have a relaxation, my lord, for the physical or even for the age, my lord. There is a relaxation, but under the scheme, my lord.
Again, I am on this notice law. This is the second law that this notice is not yet challenged law. In the present writ petition also, this notice has not been challenged law. Or it says law, after physical qualification, you have to pass through a written examination law. This has not been challenged.
Which one?
Unless this notice itself is challenged, 8 June 2024. First notice. After participation, that law is there, but this notice itself has not been challenged.
But that may not may consider that kind of the brush up saying that we can do anything out of the schemes, my lord. It has to be under the schemes, my lord. So if they have considered the other economic...
Mr. Law is also there.
Yes, my lord.
in the constitution, nobody can take a plea that they are not aware of the law. Eligible, widow, indigent, nobody has the right to take a plea that they are ignorant of the law. It is settled. It is constitutional.
And
principle.
even if that plea is taken, Lordship,
that
but
has been
without
taken.
challenging this notice, Lordship, that plea has to be taken in order to challenge the notice itself, Lordship, which has not been done.
8 June. That process started then.
Then, Lordship.
Well, I will just take to, because I have not taken the earlier process, my lord. Earlier process I have not gone through. We have only went straight way to the last impugn order, my lord.
Yes,
Yes, my lord.
last, but the process started on 8 June.
Yes, my lord. I'll just take to
Now
the.
let us see your challenge.
Yes, I will just take to the, my lord, I will just take to the annexes, my lord, how they have started, my lord. I have not gone that one, my lord. My lord, I will just take to first annexes, my lord. My lord, I will take to the first annexes, my lord. Is in 104, my lord. 104. How they can have 2-3 advertisements, my lord, when everything the process was completed, my lord. I will just, I will
Lordship may see the prayer itself, Lordship, and read petition, Lordship.
my lord, page 104, my lord. The beginning was the 104, that is on 4th February 2021.
If you, when I reading something, if you are making submission, I am nowhere.
Oh, sorry, but I will just. So relevant, I will take to is your receipt may see annexure 4, 104. That was inviting the applicant for the completion appointment on the completion ground, my lord. And on the basis of my lord, annexure 5, my lord. Annexure 5, my lord.
Just a minute, sir. Where is Annexure 6?
My lord, Annexure 6 in page 112.
112,
my lord. So this was the, my lord.
I not ask for any further. What is this PST? Means
Physical
standard test.
physical standard test. What is this government letter, page 113?
My lord.
Page 113.
113.
What is this government letter? A separate
Yes.
guidelines for completion.
But they have not come up, my lord. They say that they want to bring some separate guideline for the.
That is not on record.
Not on record. They have not filed even.
Yes, Mr. Page 113.
113 lordship.
There is a mention, second paragraph. Separate guidelines.
Seems lordship, at that point of time, there was a confusion so far the guidelines is concerned, lordship. So, seems lordship, there were lordship.
Yes. Then
lordship, kindly come to page 63, lordship.
No, 114.
114.
Yes, ma'am. Yes, ma'am.
Then same DGP says, as per existing government office memorandum. Right?
Yes.
So in the meantime, maybe separate guidelines for in respect of police department may have been framed.
Lordship. Therefore, lordship, kindly come to page 63, lordship. Therefore, I'm taking lordship to page
63,
lordship. This is police department, they don't have their own lordship. They have
Right.
not promulgated. But this is the adoption lordship. Adoptions of consolidated guidelines on compassion appointment. This is by the state of Arunachal Pradesh.
This is on 8 April.
8 April 2023
Yes.
lordship.
So there is no separate guidelines for
Yes,
police department.
Yes,
according to you.
Yes, lordship. I have already spoken to them also.
The committee has prepared this report at page 116.
Yes, my lord. Yes, 116.
Of the repetition.
Yes, yes.
That is all these criteria you are considered.
Yes.
Right.
Yes, my lord.
Educational qualification of the applicant, date of birth, category, succession certificate, income certificate, right? Age on so and so. Remarks. Then definitely one is having 20,000 annual income. Other is having 2,40,000 annual income. Right. And those some yes, those should be thrown out. If annual income is to be given, some are given, some is nil, some are no supporting document, those are to be screened out. But you have introduced this 8 June, which otherwise it is to be examined more. I have to find out the concept. It feels both ways.
And one more thing, just lawsuits, spiritual laws. This
Your lordship has seen the report. I think they should have considered on the basis of the report, my lord.
This is tentative view, but they proceeded.
Yes.
You also accepted.
This is lawsuit guidelines lawsuit of South Central Railway lawsuit. This for compassionate lawsuit, see the subject lawsuit. Uniform guidelines to be followed in compassionate ground across the South Central Railway lawsuit. If lawsuit see the clause 4 lawsuit, conduct of suitability test lawsuit. Here, why I'm because to get the best lawsuit, how for that particular post lawsuit, physical standard and other qualification lawsuit.
Physical standard is okay.
Here, written examination also is given lawsuit.
But that is also doubtful.
Here also written examinations, as it's required for that particular post. Since the petitioner has applied lawsuit, but this is not.
No, why is tasting the deserving candidate? Basically, what is the concept? To tide over the financial crisis.
That part lawsuit. I agree on the part.
So that concept is done away with. You have suppose the post required qualification of matriculation.
Lawsuit.
Only candidates having matriculation qualification will be shortlisted out of the compassionate appointment candidates.
Lawsuit.
Right? And thereafter, suppose it is a police force, then physical attributes are to be fulfilled. Right?
Lawsuit.
And before that, first you have to pick up the most deserving candidate to see whether that candidate requires immediate financial assistance or not, subject to eligibility criteria regarding educational qualification, and if it is police force, physical attribute.
Lawsuit.
Right?
That is their lawsuit.
So thereafter they join the regular cadre.
And so far police department is concerned, we have one typically lawsuit. In other post lawsuit, so MTS and LDC and all lawsuit, vacancies errors lawsuit, limited lawsuit numbers lawsuit. But in constable and all lawsuit, the post is created in bulk lawsuit, in 100, 200, 300, 400 lawsuit. All of sudden lawsuit post comes up lawsuit. So under this circumstance lawsuit, suppose say one post is vacant in the constable lawsuit. So for that particular one person lawsuit, because he has to undergo lawsuit training also lawsuit. Some difficulties there lawsuit to test.
Right, page 31, we can find out the educational qualification. These are all qualifications. Required educational qualification.
Page 31. Lawsuit.
Mr. Counsel,
Yes, my lord.
tell us how many of the petitioners fulfill this qualification. If it is required educational qualification as per the rules,
My lord, I think, my lord.
you on the next date. Because
Then
see, 10 pass candidate and knowledge in playing band. Knowledge in playing band. Possessing valid driving license of HMV and LMV. If these are the things recruitment rules have prescribed, then all the petitioners must have this. How many of them?
Okay.
How many of them?
my lord,
How many of them? Just get the information.
I have to get the information. My lord.
Because if none of them have the qualification, no point.
But then,
No point.
Then, my lord, we may allowed to file additional affidavit giving all details. my lord. Yes.
How many of them?
Yes, my lord.
As per page 31. These are the only vacancies which are to be filled up by this process.
Yes, my lord.
None else. Right? If because 12 pass with maths and chemistry is a criteria laid down in the rules for head constable, civil police, these two posts. So we must have, I don't know whether any of the widows have this diploma in electronic and communication from recognized institute. Right. Similarly, how many of them are matriculates? Right. We can set aside the appointment process of select constable, 10th past equivalent from recognized board. There are only 28 posts. We can set aside. But if you do not have any of the other qualification, you cannot compete for those posts. Right? Only thing will remain is constable, 28 number of post. Second one. Right. Have you understood?
Yes, my lord.
Then we can only interfere with those. Otherwise, they are not concerned with. We are limiting the scope of the writ petition. Whether we'll interfere or not, there is a different issue. But firstly, let them make their position clear. Right. I had so-and-so for the petitioners and Mr. So-and-so. You were there. For whom?
For private respondent.
How you have come?
Sir, I have included myself.
Oh, implemented yourself.
Yes, sir.
Okay. Number? How many?
Lordship, private
For the
respondent
private
number
respondent,
5, 7, and 8, Lordship.
The petitioners, in this petition, the petitioners have put to challenge the procedure adopted by the state respondents to make appointments on compassionate ground in respect of a number of vacancies, as indicated in a notice dated 22/8/2025. Full stop. The post-wise vacancies, required educational qualification and a scheme of written examination was shown in a table in the following table as per the existing recruitment rules in a notice, page 31, table continue. Where the petitioners have raised objection as regards conduct of written test for filling up the aforestated vacancies on compassionate ground. Full stop. As the vacancies notified in the notice have certain prescribed educational qualification indicated therein as per the existing recruitment rules, the petitioner 68 in number. 68 in number?
Yes, my lord.
shall file an additional affidavit providing the details as to how many of them fulfill the eligibility required educational qualification as per the recruitment rules by way of an additional affidavit. Right. You take note of the education qualification. If you have any of the widows have the required trade certificate in playing bands, we'll consider. Otherwise, we'll no point keeping this in abeyance. His IA may be allowed to that extent. Thereafter, how many of them have passed matriculation? Then we'll consider about the 28. You may not have, all the widows may not have diploma in educational electronics and communication. So no point for them to pursue these vacancies, and no point keeping them vacancies with the examination, right? Because state need and others are not objecting. So let us confine the scope. But your right is definitely tested, that written examination. Within what time you can give? The court is of the considered view that if any of the petitioners do not have the prescribed educational qualification for any of the vacancies, they would not have primacy, they would not have any legal right to be appointed in those posts. Post of this additional affidavit is required in view of the fact that an interim order is in operation, whereby the written examination held. Results of the written examination whereby it is wherein it is observed that the final results of the written examination should not be declared without the leave of the court. Right? Place the case on.
Maybe up to 3 weeks. 3 weeks, my lord, minimum.
Place the case. We posted it.
Yes, my lord.
Give it.
2 weeks, Lordship. Only the qualification has been filed because selection process.
At least your IA to that extent can be allowed. For the time being, before tasting this
11.
issue.
11 May.
11.
Apply.
I keep this judgments so that you can give.
Lost.
Item number 7.
Lordship.
Yes.
This matter was taken up yesterday and Lordship had asked to produce 2 judgments regarding the NOC, non-issuance of NOC.
Yes, madam.
Yes, doctor. This can be disposed of.
Okay, let it be. I'll dispose of. Heard, Mr.
B. Padung.
B. Pali.
Padung.
Learned counsel for the petitioner. And the judgment yesterday?
Yes, Lordship, I've given, I have given in the.
Oh, it is somewhere at the table. Let's find out. We will not say much. If you want to evict him,
Yes.
you follow the procedure of the.
Yes, doctor. I have gone to the earlier doctor, judgment also. They have also said the same thing.
And Miss, here for all the respondents.
Lots of. Yes, all the lot respondents.
Oh, Mr. Partin. I'm sorry, I skipped off my mind. That's matter. Monday we can make an effort. Right? I forgot actually. After the division means.
Yes.
We posted on Monday.
Monday.
Right? No need. I'll not keep you waiting.
Yes.
Monday. Item number?
8 next.
8.
Monday.
I'll dispose of this one in the meantime. Madam, you are for which respondent?
For all the respondents.
Sir, it will be on Monday because
1 to Lordship. 1 to 7.
Ms. So-and-so, Lanet, you are senior government advocate?
No, Lordship. Additional senior government.
Additional senior government advocate for the respondent. No, for all the respondents.
Yes, Lordship.
Full stop. Para. The petitioner was initially appointed as work charged within bracket mention employee against a post created by government order dated 19/9/1991 in the Rural Works Department, West Kameng District, Bomdila, Arunachal Pradesh. Post up. He joined pursuant to the order. No, petitioner joined as work charge mason on 20/05/1992. Post up. Subsequently on 29/1/1993, the service of the petitioner was regularized by an order of event date from the date of his joining the service. Post up. After serving, during his service tenure, the Rural Works Department got bifurcated into two departments,
Works Department.
namely Rural Works Department and Public Health Engineering and Water Supply
Yes.
Department. And after bifurcation, as per his option, the service of the petitioner as workers mentioned was in the Public PHE and WS Department. Full stop. After serving, the petitioner has stated that after serving, for serving in a department without any blemish, the petitioner was to retire from service on superannuation on and from
1/01/10/2025. 01/10/2025.
Cannot be 01.
1st October.
Cannot be. If
is,
it will be if your date of birth is 1st October, you will retire in the previous date.
Yes.
Okay. It will be at the end of the month. Which date? You retired.
As per his representation, it is 01/10/2025.
Okay, it cannot be, sir. Your petition here says that 30/10/2025. And at some place you are saying that 39/2025. Where is the document? You are supposed to deposit. It will be 39.
It will be 30/10/2025.
No. It will be 39. 30. Right, madam?
Yes.
30/09/2025. Post of para. 34 years after service of about 34 years. Huh? petitioner was supposed to retire on reaching the age of superannuation on and from 39/2025. Full stop. Para. The by an order dated 2/4/2013, issued by the Department of Vigilance, Government of Arunachal Pradesh, a vigilance certificate to a government employee for settling retirement dues and a no objection certificate from the concerned Deputy Commissioner stating that the government employee has not encroached upon any government property nor has caused any damage or government property were made compulsory. Full stop. A circular dated 14/2/2022 was also issued by the Finance Department, Government of Arunachal Pradesh, also to continue, stating inter alia that the pension papers of a retiring government employee are to be submitted not later than 4 months in advance of the date of retirement of the government employee. Full stop. As by the order dated 2/4/2013, a no objection certificate was sought for, and the petitioner was going to retire on and from 39/2025, the petitioner submitted an application for issuance of a no objection certificate on 28/05/2025. Before the and the same was duly forwarded to the jurisdictional deputy commissioner, that is the deputy commissioner, West Kamen District, Bomdila, for issuance of the no objection certificate. Full stop. But despite submission of the application for the NOC, the same was not processed during a subsequent period. As the petitioner was to retire from service on reaching the age of superannuation on 30/9/2025. The petitioner petitioner filed a writ petition. The filer present writ petition on 22/09/2025, seeking inter alia the direction to the respondent authorities to issue an NOC. You need vigilance clearance also.
For vigilance clearance, NOC is required.
NOC for the purpose of vigilance clearance, so as to receive the pensionary and other retirement benefits due to the petitioner for his on his retirement on superannuation. Where it is the case of the petitioner that when after submission of the application for NOC before the jurisdictional deputy commissioner, he went to inquire for the regions inquire to know about the reasons for the delay. The petitioner was verbally or informed that the NOC would not be issued to the petitioner for the purpose of vigilance clearance, that the petitioner was allegedly in occupation of a was allegedly in unauthorized occupation of a government plot of land, which would come under the purview of the provisions of the Arunachal Protest Public Premises within bracket Eviction of Unauthorized Occupants bracket close Act 2003. Close stop. The learned counsel for the petitioner has, the petitioner, in this petition, the petitioner himself has fairly where is your admission? Fairly admitted that he or she? He is in occupation of a plot of land measuring 66 square meter at Medical Colony, Bomdila, which is a government land since, since 2000, the petitioner has further mentioned that on the state government plot of land, he has constructed a house and has applied for allotment of the state plot of land on 23/12/2015. It is further mentioned that since 2000, since the year 2000, the family of the petitioner has been staying in the state government plot of land by paying by duly paying the requisite water and electricity bills. Para. It is submitted at the bar that the case of the petitioner is squarely covered by the judgment and order dated 4/8/2015, passed in WPC number 123 AP 2015, and a judgment and order dated 26/5/2016, passed in WPC number WPC 262 AP 2016. Full stop. Para. It is the right to receive full stop during the pendency of the writ petition. The petitioner stood retired from service on reaching the age of superannuation on 30/9/2025. Full stop. The respondents were put to notice on a line to WPC settled cover case officially. Petitioners were put to note, respondents were put to notice on put to notice on 23/9/2025. Full stop. No counter has been filed on behalf of the state respondents till date. Full stop. Absolutely covered case. The right to receive pension and other retirement benefits after rendering service for a long period as per the extant rules is available right which is vested in a government employee. First off, the requirement of obtaining a no objection certificate for vigilance clearance for a retiring employee, government employee, has been brought in place by way of executive instructions. Full stop. Para. If the petitioner is found to be in unauthorized occupation of any government plot of land, which fulfills the definition of public premises under the Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupants Act, 2003. A procedure has been prescribed in the Act itself for eviction of such unauthorized occupants. Full stop. Para. In the judgment and order dated so and so. And the judgment and order dated so and so supra. It has been okay. Page 60. Page 60. I have perused over mark for this. Deputy Commissioner, which district?
East coming.
West coming.
West coming, Bomdila.
West coming, Bomdila. Page 60, last two paragraph, and 61, right?
Yes.
Issued a NOC within 30 days from the date of receipt of a certified copy.
Yes.
And if you have the liberty to take action for eviction of the petitioner from the.
Yes.
Both are independent.
Hello, plus.
Facts are okay.
Yes, yes.
Item number 12.
Obliged.
Here, my lord, this counsel for a petitioner has requested me for adjournment of this case, madam.
Counsel for a petitioner.
Yes, madam.
Have requested you.
Yes, madam.
Okay.
For
Mr.
tomorrow, my lord.
B. Pichal, and you are standing counsel.
Yes, I'm standing counsel.
Standing counsel, which department?
RD, Rural Development.
Rural Development Department is present. Mr. Pichal has submitted that he has been requested.
Yes.
By the relevant counsel for the petitioner.
Yes.
To seek an accommodation on his behalf.
Yes.
First up, in view of the above submission, let the case be listed after 2 weeks.
Tomorrow.
Huh? Tomorrow for what?
My lord, this matter has become infractious actually.
Okay.
So he wants the dismissal in his presence.
Accommodation for the day.
Right.
First up, in view of the above, let the case be listed tomorrow.
My lord. Obliged, ma'am.
Item number 14.
I have gone through the judgment laws. Facts are little different laws.
Little different?
Facts are different, but
okay. What is the case about? I am myself forward.
Disqualifications.
Okay.
From
then let us await service report in respect of response number 2.
Your Lordship, The facts, maybe the facts is different, but the case is similar in nature, Your Honor.
Let the respondent number 2 appears. Let respondent number 2, Mr. You are representing?
I'm for the state lordship.
Let this respondent number 2 appear because it is for his appearance. Thereafter, we'll dispose of.
Your Lordship, till the interim may be given.
No. Court is not granting any interim order. Court has not granted any interim order initially. How can it? I wait for the service. Right, Mr. Tang?
Yes, okay, thank
you. Tang, learned counsel for the petitioner. I'm also learned Tapin. State respondent number 1
and 3 lordship.
1 and 3. 1 and 3. First off, in view of the office note dated 21/4/2025, await for the service report in respect of respondent number 2. List the case on so and so. I'm giving a fixed date. Find out. Had he agreed, I would have disposed of. Now, otherwise, at 4:30, I will not apply my mind.